Okay. You live there? Okay, over here we have YouTube. Right here we have TikTok. Over here we have Facebook. Maybe just enough that maybe we can get subscribers to come in. Maybe we can get subscribers to come in.
Justin, I'll go up front.
All right, guys. So we're in Portland, Oregon right now. This is the third stop on the We Shall Be Free tour as we continue to collect these affidavits, return to Washington, D.C., where we will deliver them to this proceeding. Guys, my name is Tanawah M. Thank you all for joining me. I'm a national civil rights advocate and litigator out of Washington, D.C., and again, we're in the middle of 40 individual stops across this country, 40 cities. The path and route was released yesterday, I believe, for us, day before yesterday. It's available, readily available. If you guys have questions as far as where we're going to be stopping, what cities we're going to be in, reach out to myself or Justice Without Limits. She'll be able to provide you with that information. We also have a number of other people that are helping out. Sandy is incredible. That's Ms. Jax. Appreciate all of you for your help. We also have Rainbow as well. She's helping out. We have the real. I'll get back to you on that. But we have a number of people that are helping out, and I appreciate the support that you guys are providing to be able to see this coming to fruition. You guys know what I'm doing, right? And if you don't know yet, then we're gonna make you guys aware of exactly what's going on right now today. Okay, so I'm not going to be focused on the video, guys. I'm not reading your comments. Okay, so if you guys provide comments on the lives, just understand I'm here focused on the people. I'm going to respond to their questions, their issues, and not so much on all of you. And I apologize for that. But okay, so again, my name is Tanawah M. Thank you guys for showing up. And we're now litigating what will be the biggest civil rights case in American history, hands down. This is going to make Brown v. Board of Education look like a small claims court. If you understand what Brown v. Board of Education was, it was a case that overturned the case called Plessy v. Ferguson back in 1958. Plessy v. Ferguson was an egregious ruling made by the United States Supreme Court under the Waite Court, right? And Chief Justice Waite, his court is the exact court that we're fighting with currently on the issues that we're trying to get resolved as well. So this was a court that was a science experiment at the best. They put into place terrible rulings such as Plessy versus Ferguson, the slaughterhouse cases, the Hurtado versus California, which is the one we're trying to deal with, Santa Clara County versus Southern Pacific Railroad, which made personified corporations. These are terrible rulings that were not embedded within constitutional law or within American law. It was embedded within a desire to proliferate and advance the slavery institution. And I'll explain to you guys the reason why. Again, this is going to be the biggest civil rights case in American history, hands down. So what we're doing here is, I think that we would all agree that the Constitution of the United States of America is the supreme law of the land. Right? The states, they gave up their sovereignty to join the Union and subject themselves to the supremacy of the United States Constitution. I think that anybody with basic civics classes would understand that particular concept. But what happens when a state chooses to exceed the power or authority statutorily conferred upon it by the Constitution in its acts of creating laws? What happens when a state chooses to abridge their obligations or their restrictions in the Constitution in order to deprive people of the fundamental constitutional rights that are specifically enumerated and written within the Constitution of the United States of America? That's the issue at hand. What is the role of these states within our society? A union is defined as two or more non-sovereign states with a centralized governing structure. Now, a non-sovereign state is defined as a state that is not complete in itself, subject to a higher government's laws, right? Subject to higher government's laws. So these states, they gave up their sovereignty when they joined the Union in order to subject themselves to the Constitution of the United States of America, right? You understand that, don't you? Okay, so I have a constitution here, a state constitution, for instance. This is North Dakota's state constitution. And let me tell you right now, North Dakota's state constitution under Article 1, Section 3, Article 1, Section 3, it says, the state of North Dakota is an inseparable part of the American Union, and the Constitution of the United States is the supreme law of the land. Let me read that again. The state of North Dakota is an inseparable part of the American Union, and the Constitution of the United States is the supreme law of the land. You see, these states that gave up their sovereignty to join the Union and subject themselves to the supremacy of the Constitution for the United States of America. Therefore, states do not have the authority to be able to create their own laws and then enact them and then put into place and remove the fundamental rights of the people of the United States that's preserved and protected under the Bill of Rights and the Constitution of the United States. They don't have the right to be able to substitute their alternative legislation for the provisions and guarantees of the Constitution of the United States of America. That's a very simple concept. And yet here in North Dakota, for instance, they have decided to remove a grand jury proceeding from their inferior laws. Their Constitution permits their prosecuting attorneys to charge by information, not by indictment, despite the fact that the indictment is required by the Constitution for the United States of America. Guys, here's the Constitution, okay? So the main body of the Constitution, Articles 1 to 7, that creates the obligation of government, right? Obligation of government. But then the second part of the Constitution is called the Bill of Rights. It's the first 10 amendments to the Constitution. Now, Clause 1 of Amendment 5, that's certainly part of the Constitution. It was adopted and ratified by the people on December 15, 1791, in all intents and purposes. Nobody is arguing as to whether or not the Fifth Amendment is part of the Constitution. Clause 1 of Amendment 5 says, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. That's clear. You got to have an indictment by a grand jury before arresting someone and holding them over for a capital or an infamous crime. I'm in Oregon right now, guys. Oregon, the inferior constitution here in the state of Oregon, it permits the prosecuting attorney to charge by information or indictment by their discretion. Unfortunately, discretion can never be used with regard to one's constitutional obligation. Obligations must be performed, right? They must be performed. So the reason why is because an obligation is what the law creates. And so when the law or the Constitution creates the obligation for prosecuting attorneys to charge by indictment, not by information, then that officer, when they're permitted to use their discretion to break the law, that would be an abuse of discretion, right? And that would make it unconstitutional. Now, the unconstitutionality of this particular law here in the state of Oregon is actually through the 14th Amendment's Equal Protection Clause. Because the Equal Protection Clause says that no state shall create or enforce any law that shall not provide equal protection of the law. So when the prosecuting attorney is able to use their discretion to determine who gets a constitutional right and who does not, that would clearly be a violation of the 14th Amendment's Equal Protection Clause. So the reason why I bring this up is because today, right now, there's more than 700,000 people currently in prison here in America on direct facial constitutional violations because there are 13 states that do not conduct a grand jury, despite the fact that it is required by the Constitution of the United States of America. That's what we're getting ready to argue. That's what we're collecting. That's what we're returning to Washington, D.C. to address, is the fact that when these states choose to enact their own alternative legislation, and then substitute that for the guarantees of the Constitution, that would be unconstitutional. And so we need to decide, if we as a nation, what is it that makes America America? Is the Constitution of the United States the supreme law of the land? Does it have the power that we believe that it has? Is that the faith of the people? And if it is, then we know the path we're going to have to take to remedy this situation, right? Because I like to talk about, these prisoners, right? Because when our countries first started, when we were first founded, our founders and forefathers, they said some things that were pretty incredible. I think that we would all agree You know, this concept of all men being equal. What an amazing concept, right? What an amazing thing. But unfortunately, as you all know, I'm trained in identifying lives. That's what I did when I worked for intelligence. That's what I did when I worked for Department of Energy. What I did when I worked for Department of Homeland Security. I identify lives. And your words and actions must align. If they don't align, then you're a liar. You're a liar. And unfortunately, you know, I have great admiration for these men, Thomas Jefferson, George Washington, James Madison, you know, these founders that created this concept. But what I have a problem with is that their words and actions didn't align. We had a number of founding fathers who said that they believed in all men being equal. They believed that these laws must apply equally to all men. They started what was known as the egalitarianism form of government, which is the belief that all men are equal because laws apply equally to all people. But when it came right down to it, did they make all men equal? They did not. They did not, because they refused to give up what we call their property, right? And they decided to keep their slaves. Now, a lot of people argue with me, and they say, yeah, but they didn't believe that they were equal, right? They didn't believe that they were equal, which is what's said. They didn't believe that they were equal. And I will not buy that. I cannot subscribe to that narrative, because George Washington, Thomas Jefferson, James Madison, when they died, in their will, they released their slaves. So they only kept their property so long as it was financially advantageous to them. But the moment that it was no longer financially advantageous, then they released the slaves and made them people once again. So I can't accept or buy into the narrative that they didn't see these people as equal, because if they saw them as just property, they would have just passed them down as though it was any other property, you know, to their grandchildren. So I'm not going to buy that narrative. But the point that I'm trying to make here is that our founders and forefathers, they created this concept known as egalitarianism. And they said that we believe that all men are equal. We believe that the laws apply equally to all men, but they didn't actually do what they said that they were going to do. They didn't create that. They didn't create a just system. They created a criminal enslavement system, because slavery is and has always been the foundation of American jurisprudence. And we know that from a number of different things. First off is the Fugitive Slave Act. A fugitive is a slave is a fugitive. When you read the Constitution of the United States, these men, they said that when a fugitive flees from one state to another, that state is to return them to the original state. That fugitive wasn't a criminal. That fugitive was a slave because of the Fugitive Slave Act. A slave is a fugitive, and a fugitive is a slave. Those are synonymous terms with one another. Now, the other way that we know what they're talking about is the 13th Amendment. This is the very amendment that was adopted and ratified by the people after 1 million of our people died in a war, fighting in a battle for equality, right? 1 million of our own brothers out there fighting against this institution that we call slavery. And don't tell me that those men and women died for anything less than for this battle, because we're going to have some fighting words for that. People do not go out and fight for with their lives and lose their lives for anything less than faith. Okay, they believed in what they were doing. Now we know that the war machine had a different agenda, right? But those people that lost their lives, they were not there for anything short of what they believed in their faith. And I want us to make sure that we honor those that died in this process, because we are fighting the most incredible and the most significant battle today. This is the battle for equality, and we're going to win this battle. We are going to win this battle. But equality means equality of all men, all women, all children, everyone is going to be exactly the same, because we're going to make sure that these laws apply equally to every single person. But the 13th Amendment, it was adopted and ratified by the people in 1865, immediately after the war, adopted and ratified by the people. And it was supposed to abolish slavery. But I'm telling you right now, it did nothing of the sort. Not only does it permit slavery, but it codified the legality of it within our foundational law. Because it doesn't say you can't have slavery. What it says is neither slavery nor involuntary servitude shall exist except as punishment for crime. When we say except, it means that you can have slavery. We're going to call it justice here in America. So we simply took something, we retitled it as something different. We changed it from private institution to public institution, and we told America it doesn't exist anymore. But it does. It is very much alive and work here in America, destroying our system of government, bridging on the rights of people, and these states have realized the tens of billions of dollars that they can make off the forced involuntary servitude of the weakest and most vulnerable in our society, and all they have to do is label them an average criminal. We have a system that takes our own people, right, and it creates laws and says, well, this is a crime. And then it goes and investigates what it says is the crime. And then it goes and charges you for what it says is the crime, right? It brings the accusation. And then it judges you for whether or not you've committed this crime, and then it profits off of your involuntary servitude, enslavement, in a for-profit business that is the direct benefit of the state, read your state constitutions. This is what they're doing. There is no neutral, unbiased decision maker in this process. That neutral, unbiased decision maker is known as a jury. And it starts with a grand jury, and then it goes to a petit jury. And so there are a couple questions here. I wanted to open up with that. I want you guys to understand the true mechanics of this system and the fact that we do not have a criminal justice system. But we can. But it depends on what it is that we believe in. Do we believe in the Constitution of the United States, the charter of our nation, the very document and laws that create our government, give it its authority, grant them their power, or do we believe that judges make the law? Do we believe that judges control our destiny, or do we believe we the people do? That's the issue at hand. That's what this case is all about. Does the judicial branch have constituted authority to be able to create law, or do they create rulings? Case law is not law. We, the people, did not delegate any constituted authority for judges to be able to create law. We reserved it to the people under Clause 1, Article 1 of the Constitution of the United States. All legislative power is vested in a Congress of the United States, consisting of a Senate and House of Representatives. There is no authority for judges to be able to legislate here in the United States of America under our Constitution of government, and yet we live in a society where judges control the law by what they call case law. Judge made rulings. Yes, sir.
Great presentation so far, by the way.
Thank you.
I applaud you. Is kind of peripheral questions. Is this going to be an ongoing talk today from 1 to 4?
Yeah, so we're here for 4 hours. It was supposed to be noon to 4, but the library didn't open up until then. It is 4. So what I'm doing is I'm on a national tour around the country. This is stop number 3 out of 40. So between now and June 6th, we're ending in New York City on June 6th. And so what we're doing is we built a case. This is the biggest civil rights case in American history. We have right here about 120,000 criminal affidavits on behalf of the people of the United States for crimes that have been committed against them by government, and I can explain what these crimes are. We have a goal of 500,000. We will probably exceed that significantly, but we built a case. Right now, the Supreme Court of the United States is ignoring us, but we're just going to get a little bit louder. But between now and June 6th, we're collecting these affidavits, we're doing these town hall meetings, we're trying to bring awareness of this issue up, and as we do that, then when we return to Washington, D.C., the expectation is that we will take these 500,000 criminal affidavits, we're going to bring them to the Supreme Court of the United States, and we're going to ask them, are you ready to let me litigate this? Are you ready to let me debate this issue with you? And if not, then the Supreme Court of the United States will be responsible, culpable, and the reason why these treasonous acts are occurring. Because the Supreme Court of the United States, ever since it was established and put into place, they've been putting into place rulings that have been undermining the laws of the United States, the Constitution. They've been putting into place rulings that have been undermining the Union, right? And in doing so, what's happening is that we have the fundamental rights of the people codified within the Constitution, the Bill of Rights, first 10 amendments. And when it says that you must do something, and then the judicial branch says, oh, we're not going to do it, what happens there is that the fundamental rights of the people that we can see, the enumerated rights of the people, have been removed and replaced with judge-made rulings. And now the judges became the supreme law. They became the foundation, not the Constitution of the United States. What we're doing is we're saying to the Supreme Court, you have no authority to be able to legislate. You have no authority to be able to create law. Your rulings are just that. But rulings must be consistent with the positive law that people create. Because if not, then that means that you are legislating to the bench. And you've been doing that ever since you first started. So my fight is with the Supreme Court of the United States to remove the erroneous, unconstitutional things that they put into place, put back into the foundation of the Constitution of the United States in its rightful place within our system of government, so that people can live in a world that's predictable, that's consistent with what we believe in our hearts and our minds, and not consistent with a bunch of slave owners, because of the first 28 justices that served on the United States Supreme Court, 22 of them owned their own slaves, and that's why we have slavery at the foundation.
Sure. So do you personally trust the Donald Trump Supreme Court?
I don't trust it either. And so unfortunately, Mr. Trump has been notified of this on multiple occasions. 3 separate occasions he's been informed of this particular case, what I'm doing. and he's been informed ever since last May. So he's had over a year now to be able to consider this issue. And I'm going to tell you that this is a big issue. There's more than 700,000 people currently imprisoned across America today on direct facial constitutional violations because Mr. Trump's own agents, the prosecutors, the attorney generals, are all choosing to rely upon an inferior state law that permits them to abridge the guarantees of the Constitution of the United States. That means that he himself is sanctioning this behavior. And that's why this morning, you know, it's not, and this is not about politics, all of you. If you guys start saying something stupid about this, then we're going to block you, because my fight isn't with you. You guys need to understand that. Everybody that's on these lives here, you guys need to understand, my fight's not with you. But if you make the fight, if you get in between me and the end user, the audience, the people that need to hear the things I'm saying right here, then we are going to remove you from your ability to be able to continue to hear me, right? Because I'm not fighting with you, but I am fighting with the top of all three branches of government. And you guys need to as well, because the problem is the leadership of all three branches of government. And this is not an individual right or left. This is not democracy versus republic. This is a situation where we have a bunch of people who are heavily invested within this industry, that are profiting off of the very decisions that they make to advance their own financial interests. And I don't care what side they're on, I don't care blue or red, I don't care what state they're in. We talked about this just this morning on this live. When you look at the democracy and the Democratic, the blue states, they are overspending. That's what DOJ is now working on. That's why DOJ is focused on blue states, because the red states or the red party cares about money, right? Why are we spending so much money? But I'll tell you what, that doesn't relinquish the red states of any responsibility, because I'm going to tell you, the highest rates of incarceration in this nation come from red states. Oklahoma, Florida. And you know why? Because they're seeking to advance the business, right? So the red states, they care about making money. The blue states care about spending money. That's kind of what we're seeing right now, right? That means that both sides are wrong. Because the rights of the people is what I care about. That's what I want. I want the people to get what they're entitled to. And unfortunately, the rights of the people are contrary to the business of government. That's the problem. So the answer for you is that no, Mr. Trump is not behind this. And he's focused on finding out where the money is being spent. But money has to do with business. And I've been saying this for quite some time.
Has to do with what?
Business, a business. Government is a business,
yeah,
right? And unfortunately, when we consider government as though it's a business, then that means that the decisions that we're going to make are going to be what's in the best fiscal interest of the country, not what's in the best societal interest of the country. And therefore, we're going to create laws that are going to be focused on how can we make money? Because government, unfortunately, makes money at the expense of its citizenry. And there's the situation that we're in, right? I don't care about the money. I care about the rights. And the rights are always going to be in conflict with the business of government. So we don't want to run government as though it's a business anymore. We've got to get government out of the business, out of the industry, because we need the people to be protected. And the sole purpose of our government, the day that it was established, was to protect the rights of the people. Remember, the Constitution of the United States, its purpose was to establish rights and limit powers. In some cases, state powers are limited. In other cases, federal rights or powers are limited. And in even more cases, both powers are limited, but they're limited in order to preserve and protect the individual rights and individual liberties of people, right? So when a state says, we're not going to do what we are restricted to do, we're not going to do what we're obligated to do, we're not going to have an indictment by a grand jury because we want to be able to streamline the business so we can increase the imprisonment and arrest rate, so we can make it so that we focus on speed and efficiency as opposed to what the established procedures and processes that are in place to protect the individual liberties of people. When we do that, states, guess what? You are now acting with unlimited power because you are limited through the Constitution of the United States of America. So just as I said in North Dakota's Constitution, the state of North Dakota is an inseparable part of the American Union. And the Constitution of the United States is the supreme law of the land. Supreme law of the land. And so, that would be constitutionally, here is North Dakota if you'd like to look through it.
Okay.
Most state constitutions are very, very similar, okay? They're very, very similar. And so, but one thing that's very, very important to note is that every single state constitution within the first article has named the United States Constitution the supreme law of the land. I'm gonna tell you guys, like when I first started, this particular pursuit, this particular litigation, I was concerned. I was concerned because these judges are taking an oath to both the state constitution and the federal constitution, right? I mean, there's a Justice Without Limits has a current video out right now where she actually has one of the judges in Blunt, Tennessee. She has her actual oath, the words that she stated the day that she swore oath, and she says, "I do solemnly swear that I will support and defend the Constitution of the United States of America and the Constitution of the state of Tennessee." I was like, oh no, this is where the problem's at, right? This is where we're having this issue, is that if you swear an oath to two constitutions, then what happens when there's a conflict, right? But then I went and I dug a little bit deeper and I realized that just as North Dakota says right here, the state of North Dakota is an inseparable part of the American Union, and the Constitution of the United States is the supreme law of the land. So the state of North Dakota has taken its inferior constitution and placed itself into subjection to the United States Constitution. Therefore, there is no conflict of interest. If you swear an oath to the state constitution and the federal constitution, and the state constitution has already placed itself into subjection to the United States Constitution, then it doesn't matter what the state constitution says. Your oath is with the Constitution of the United States of America. Therefore, you must follow it. You may not follow the state constitution if the state constitution has placed itself into subjection to the United States Constitution. Same thing here in Oregon. Oregon's constitution, Article 1, Section 2 has placed itself into subjection to the United States Constitution, because in order to join the Union, you must give up your sovereignty to subject yourself to the higher government's laws. That's what a sovereign state is. A sovereign state is a state that is complete in itself, not subject to a higher government's laws. Is the state of Oregon here subject to the higher government's laws, the Constitution of the United States of America? And if they are, then I'm going to tell you right now, almost every single person in your prison here in Oregon is there illegally and unconstitutionally, because the state decided that they were not going to do the very basic procedures and processes codified in the Constitution of the United States of America, restricted to the states through the Bill of Rights, when they failed to hold a grand jury prior to arresting someone and holding them over for a capital or dangerous crime. Now let me go ahead and tell you, okay, so Fifth Amendment says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. Here in the state of Oregon, again, you guys are permitted to charge, the prosecuting attorney is permitted to charge by information or indictment by their discretion. You may not use discretion with regard to one's obligations. Obligations must be performed, because otherwise you can use it abusively to break the law. That's issue number one. Issue number two is the 14th Amendment. No state shall create or enforce any law that shall abridge the privileges and immunities of United States citizens, right? Or does not provide equal protection of the law. So when the state of Portland permits their prosecuting attorneys to charge by information, not by indictment, then what you're doing is the prosecuting attorney is deciding who gets a constitutional right, who does not, which is in direct violation of the Equal Protection Clause of the 14th Amendment. So what's a capital crime? Capital crime is any crime punishable by death, right? Those are pretty easy. Right? An infamous crime, however, is a crime according to Title 18, subsection 48.3. An infamous crime is any crime punishable by more than 1 year imprisonment in a penitentiary. And it's not the amount of time that you get sentenced to, but the amount of time you can be sentenced to. Because remember, the Constitution says no person shall be held to answer for a capital or otherwise infamous crime. So it's the moment that you're held, the moment you're arrested, is the moment that we determine the infamous nature of the crime. So if you can get 2 years, but you only get sentenced to 3 months, it is still an infamous crime, because you cannot be held to answer for a crime without the indictment by a grand jury. So information is not an indictment. Let me tell you what information is. Information was created by the state of California. Right? State of California. They had an issue with the grand jury. A grand jury is 16 to 23 people. Normal peers, and what they're empaneled to do is they're there to determine probable cause, right? They're there to be an intermediary between the state and the accused, right? Their purpose is to protect the innocent from hasty or malicious charges by an overzealous prosecutor or an overzealous police officer. So when a police officer has the ability to say, oh, this person did this, and we're not going to arrest him and detain him and put him in jail and start holding him over for this offense. And, unfortunately, that police officer in order to advance this interest, in order to advance the institution, make it easier to do this, they had to eliminate the one thing that protects the accused from hasty or malicious charges from a prosecutor or a police officer. So what California was looking at is, the best example I can do is a drug offense. So let's say that the police pull you over, right? Let's say it's a completely lawful pull-over. And let's say that they search your vehicle. And let's say it's a completely lawful search, right? And they find drugs, okay? Well, who becomes your accuser? That'd be the officer, right? The officer is accusing you of breaking a state statute, okay? Well, that officer cannot be your accuser because according to Article 3 of the United States Constitution, if the state is a part in the cause, the state may not be a judge in the cause. Very, very simple. So they had to create a new accuser, and they call that accuser information. So what happens there is that this officer takes this information, reduces it to writing in the form of an affidavit, and then submits it to the judge. And says to the judge, I'd like you to hold this person over for this offense. And that judge says, well, it looks good to me, officer. We're both on the same side. We both work for the state. Yes, go ahead and hold them over. And he will order the arrest. Well, that judge is not a neutral, unbiased decision maker because he works for the same entity, the state, as the prosecutor, as CPS, as the law enforcement. They're all part of the same body of men. And when the state brings an accusation through any one of its agents, that same body of men, the state, cannot be presumed to be neutral and unbiased to act as a judge in the case. So the Constitution has declared that in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. Any time that a state brings an accusation through any one of its agents, that same body of men may not be the judge in that case, and therefore the judge has an automatic, mandatory, non-waivable, self-executing duty under the Constitution, Article 3, Section 2, to recuse himself. Failure to do so means that court is acting without jurisdiction. Therefore, anything that court produces, any action it renders, any decisions it makes, is all void, wholly without force or effect according to Civil Rule 60B4. Also, by the way, for those that are online streaming, if you guys have any questions, you guys want to watch this video once again, we are streaming to Facebook, we're streaming to YouTube. You can go to my channel, you'll be able to watch this video once again, you'll be able to share it there, break it down, whatever. Every single thing we always provide. And once again, I work for free. I chose to do this 9 years ago. I don't get paid for the work that I do because the people that I'm fighting for, they don't have money. If you're having your rights taken away from you, you're having that done because you are poor. These people need help, so I made the decision 9 years ago to do this. So I do this for free. I operate on donations only. Most of you already know that. But all of my information, if you guys take this information, you begin to try to start to sell it, you find that you're selling this information that I give freely to you, you will be blocked. You will not have access to my information anymore. And so we want to make sure that we're very, very clear on that, is that what I get from God, I freely give to you. You are not going to turn around and sell my information. And if we find out that you have, we are going to come after you vehemently, all right? So make sure we're clear there. But all this information is available on YouTube. Please share this information because it's so important that the people of the United States has this knowledge. And if I can give you $180,000 worth of education in one single sentence, it would be this. Anything that's not the Constitution is unconstitutional. Simply by virtue of the fact that it is not the Constitution, that makes it unconstitutional. So that's why I fight only from the Constitution, the highest form of law. I go to the Constitution, I speak only it. I do not come down off of it to fight down the weeds in judgment rulings, case law, or statutes, ordinances, customs, judgment rulings. That's where they want you to fight. That's where attorneys take you to. That's why attorneys lose. That's why I'm not an attorney. I'm an advocate. I speak on behalf of others, and I fight from the highest form of law. So if I can give you guys one great piece of information, it would be that anything that's not the Constitution is unconstitutional. Therefore, you don't rely upon anything but the Constitution. You speak the words it says, and when you do, you will be victorious. Yes, sir?
You just answered my question. I was going to ask you, are you an attorney?
No, so attorneys, they go through what's called adjunctive law. They learn about the adjudication process. So a Juris Doctor has a degree in adjunctive law. And so what they learn about is they learn about ordinances, statutes, customs, judgment rulings, all these things that remove freedom, because that's what they're in the business of. They make a person into a criminal. So if you have a degree that makes a person into a criminal, you have a degree in, unfortunately, slavery. Because remember, the 13th Amendment made synonymous prisoner and slave. Criminal is a slave. Criminal is a prisoner. They're all synonymous terms. So a person that has a degree in Juris Doctor has a degree in slavery, has a degree in removing freedom, I have a degree in substantive law, which is the exact opposite. I'm an advocate. I speak on behalf of others in a legal matter. They act on behalf of others in a legal matter. They remove freedom. I restore freedom. I fight cases in the Supreme Court. They build cases to send us to the Supreme Court.
You have a degree in what?
Substantive law. The substance or spirit of law. Substantive means the substance or spirit of law.
Okay.
So I have a degree in the spirit of the people, right? And that's what makes me happy. So my education, I graduated from George Washington University. I have 3 master's degrees, one of which is in substantive law, which is the substance or the spirit of law. And that all that I studied was nothing but the Constitution, the laws of the United States, the things that bind the nation together. And so that's what I said. But my degree is actually law enforcement. Their degree is law administration. So attorney is an administrative officer of the court. They follow administrative law, which is judgment rulings, because the judicial branch is known as the administrative branch. Their purpose is to administer the law. So when the judicial branch creates a ruling and then erroneously and unconstitutionally calls it law, that would be administrative law. Therefore, administrative officers of the court follow administrative law. That's why attorneys follow case law, believing that is the supreme law, believing the judges speak the law because that's what they've been trained to do. I haven't been trained to do that. I deal with law enforcement. I deal with the first half. A prosecutor must have a degree such as mine because I look at things from a neutral and biased perspective to determine truth. Attorneys don't do that. So these attorney generals that are trained in adjective law and juris doctorate, that is not the position that they should be filling, right? When you have law enforcement that's being led by a prosecutor who has a juris doctorate, once again, that's the improper education. There's a whole entire knowledge base that exists here in America that's not even being tapped into, and we need to get this resolved. So I'm making the industry understand that there's a whole other education base that's necessary to fill a position that's essential within that courtroom, and that is that a prosecuting attorney cannot be an attorney. Right? A prosecuting attorney cannot be an attorney because a prosecuting attorney who's an attorney only knows how to make a person into a criminal. And that prosecuting attorney is supposed to be the highest law enforcement officer of the state or of the county. And as a result, that person must have a different type of degree, because if all you know how to do is to make a person into a criminal, then you cannot enforce the law, because law enforcement must be neutral and unbiased, and it must be one that's educated in what is truth, how to ascertain truth, what are the elements of a crime, and so on. So prosecutors cannot continue to be a juris doctorate here in America. Yeah.
Well, I never knew that about prosecutors. I thought they were just regular old attorneys.
They are regular old attorneys. They are. But when an attorney has a degree in making a person into a criminal, right? Then they're not trained in how to ascertain truth. A prosecuting attorney is the highest law enforcement officer of the county. Okay. The attorney general is the highest law enforcement officer of the state. So because they're law enforcement, then the enforcement of the law, you need to know what is or is not criminal behavior. Was the crime even committed? What is mens rea in a guilty mind, right? There's certain knowledge base that's necessary, because truth always lies somewhere between two stories. So when you listen to one side, who's your own client, because attorneys take on the client of the accuser comes in, now the prosecuting attorney is their attorney, and now they've taken one side of the story, and through an intentional skewing of the disposition of legal proceeding, they are hindering or obstructing free speech on the other side so they can control the narrative. Well, that is unlawful. Because for law enforcement, we must look at the situation. We need to look at both sides, listen to both sides. We need to collect evidence, and prosecutors can't do that when all they know how to do is make a person into a criminal. That's all they're trained to do. So they use all these laws that remove freedom, and yet they don't understand whether or not that person's even committed a crime. So we've got a pretty big problem. But let me go ahead and step in now into the familial unit, because
into what?
Into the family. All right. So my case, what we're doing, what we're about to litigate in the Supreme Court is based upon indictments. That's pretty simple, right? So when the Constitution of the United States requires that you must have an indictment from a grand jury consistent with Clause 1 Amendment 5 before arresting someone and holding them over for a capital or an infamous crime, right? When the state chooses to enact its own alternative legislation, substitute it for the guarantees of the Constitution of the United States of America, the Bill of Rights, That would be unconstitutional. Therefore, everything that they produce is unconstitutional, because if the arrest is unconstitutional, if the arrest is unlawful, everything that derives from that arrest must also be unlawful, because it is all tainted by the illegality of the way in which it was obtained. You cannot have a constitutional or an unconstitutional arrest or an unlawful arrest result in a lawful outcome. So the moment that they failed to follow the very basic procedures and processes codified in the Constitution of the United States of America, the Bill of Rights, then that arrest is unconstitutional. Therefore, everything that comes from that arrest must also be unconstitutional, because it is all tainted by the illegality of the way in which it was obtained. Now, I'm going to say right now, I'm not advocating for the release of dangerous people. I know that we have a system of government that we have dangerous people. I'm not an abolitionist by any stretch. I believe in our system, and I know that we need to protect our people from people that are dangerous to society. I know that. But the problem is that most of the people that are in prison right now today are not a danger to society. Most of the top criminologists in the world, and I'm not going to claim to be one of them, although I do have a master's in forensics, I am absolutely qualified to be able to talk on this particular issue, but I'm not going to claim to be one of the top. But I will tell you that the top criminologists in the world all agree that only about 4% of our prison population is a danger to society. 78% of the people in prison never hurt anyone but themselves, drug-related offenses. These are people that are hurting, that we're taking and putting into a more hurtful situation, and then expecting them to get happy. That's insane. That's not how it works, right? So what I'm saying is that the issue of morality, right, is a matter of public health. It's not a matter of punishment. We need to help these people understand the trauma that's been inflicted upon them, which is my segue into the familial unit. Because today, right now, we've got more than 12 million children that are currently removed from their children, from their families, mother and father, that have been placed into adoption and other means of deprivation of the familial unit. They're not receiving the love that they need to be able to become a member of society, to live within the parameters that our society has established. Because for every child that you remove from the love and care of their family, their mothers and fathers, this is a child that has an 80% likelihood of going to prison over their lifetime. 80% likelihood. The majority of these children, of the 12 million children, are going to end up in an institution because of the trauma that the institution is inflicting upon them. And then we say, oh, look at that monster. Look at what that monster did. Just one second, let me get through this thought real quick. So we say, look at what that monster did. Well, the way I like to talk about it, or the way I like to describe it is this. We have got to stop looking at what people do. Because when we look at what they do, all we see is that monster. It needs to pay for things they've done. It creates this vengeance-based system that we have in place today. But when we look at what was done to them, long before that crime, as a child, as a husband, as a mother, then we see that something tragic happened to this person. And it changed the trajectory of their life. And now we want to help them, now we want to heal them, and now we can understand the reasons why they've done the things they've done. This is what creates the forgiveness-based system, the system that actually heals and that is real justice. Because real justice is equally concerned about both the accuser and the accused, about the hurting as well as also the hurt, right? Because the way we resolve the issue of criminality in this country is by healing the hurt from those that have been hurt, right? So for these children that have been removed from their families, if we can address the trauma that has been inflicted upon them, then we can resolve this issue of criminality we're experiencing here in America today. We can do this. We absolutely can. And there's nations that we can look at as great examples. Let me go ahead and give you two real quick. The first is the nation of Sweden. Did you know that Sweden, right now today, Sweden is getting ready to shut down its last prison? They're getting ready to shut down their last prison. Why? Because they chose a restorative-based justice system that heals the trauma of the people, right? And not hurt the people anymore. They didn't choose a punitive-based. We here in America, we are the last industrialist nation that chose a punitive-based justice system. We're taking people that are hurting, that are sad, and we're putting them into an institution that is hurting them even more. And then we're expecting to resolve this issue. This system knows this. This system is well aware of what they're doing, right? So this system, it's making tens of billions of dollars every seal here of the forced involuntary servitude of the people that they create trauma in by the unlawful breakdown and destruction of the familial unit. Guys, a family can survive without a nation, but the nation cannot survive without the family. So how does an indictment, what does an indictment have to do with the familial unit? What does an indictment have to do with preserving the family? Let me tell you what it does, right? So, the fundamental constitutional rights. Fundamental rights are any fundamental right that is contained within the first 10 amendments. Freedom of speech, freedom of religion, freedom of press. Those are all fundamental rights. Okay? Right to an indictment by grand jury, that would be a fundamental constitutional right. Okay? The right to a jury trial, that would be a fundamental constitutional right. Anything that's written within the first 10 amendments of the Constitution of the United States, it is a fundamental constitutional right. Right? Fundamental constitutional right. So when you deal with a fundamental constitutional right, those are the rights that are so imperative, thank you so much, those are the rights that are so imperative to the fabric of our society that we want to call them out, right? And we want to preserve them and make them so that they are not up for contemplation by the state, right? We don't want states to be able to interfere with such rights. So we made them fundamental, okay? The indictment by a grand jury is an enumerated fundamental constitutional right. It's written, it's right there, it's enumerated within the Fifth Amendment. No person shall be held to answer for capital or otherwise infamous crime unless on presentment or indictment of a grand jury. That's fundamental. Within the first 10 amendments, it's enumerated, written right there to see, which means that 700,000 people here in America are imprisoned on direct facial constitutional violations because the states did not follow the very basic procedures and processes enumerated within the Bill of Rights in the adjudication of a crime. That's pretty clear. That's simple. I don't think that anybody would fail to understand that particular concept. But unfortunately, nowhere in this Constitution does it say anything about your family being preserved. Nowhere in this Constitution does it say you have the right to have a relationship with your child. Right? Nowhere in this does it say you have the right to have a relationship with your wife or your husband. Nowhere in the Constitution does it preserve your familial unit. And the problem that I have is that our founders and forefathers who created our country, the first act of our government should have been the preservation of the family, not the last act. We should have had the family preserved from the very beginning, and they failed to do so because they wanted to protect their property. Justice is simply a term created by slave owners in order to preserve and protect the property. You can see that because of the Fugitive Slave Act. That when a fugitive flees from one state to another, that state is to give them up and return them back to the original state. The Fugitive Slave Act, the fugitive is a slave. What they're talking about in the Constitution, when it says a fugitive flees from one state to another, it's referring to a slave. That's all it is. It's referring to a slave. It's not referring to a criminal, although a criminal is a slave and a slave is a criminal. They're all synonymous with one another. So nowhere in the Constitution does it say you have a right to have an intimate familial relationship with your children. However, the Supreme Court of the United States did make the decision in 1981 in a case called Roberts v. United States that you have the right to intimate association, meaning that you have the right to have an intimate familial relationship with your children without governmental interference, and your children have the right to have an intimate familial relationship with you without governmental interference, and that it was found to be fundamental, protected by the First Amendment. I'm going to tell you that that's a very, very important statement there, because they said that it was found to be fundamental, protected by the First Amendment. Okay? Found to be fundamental, protected by the First Amendment. Now, why the First Amendment? Well, the First Amendment are all the God-given rights. All the God-given rights. Most people don't understand this. They're like, okay, all the Constitution, all by God-given rights. No, that's not true. That's not true. God didn't make the gun. Man made the gun. Right? God gave you the right or the freedom to defend yourself, but He didn't make the gun. Okay? So, the reason why the First Amendment are all the God-given rights is because if you open up the Constitution to Amendment 1, it says you have the freedom of speech, you have the freedom of religion, you have the freedom of press, right? Those are all freedoms. They're freedoms because God allows you to speak. And until the day you're called home, you will always have the freedom to speak. Only God can take that away from you, right? Okay, so the First Amendment are all your God-given rights. God gave you the right to speak. God gave you the right to religion. God gave you the right to develop your conscience. God gave you the right to speak out against tyrants, the press. This is what God gave you the freedom to do. But the Second Amendment says everybody shall have the right to bear arms. Right to bear arms. Right to bear arms. That is a civil right. It's not a freedom. First Amendment are freedoms given by God. Second Amendment are rights Now, what is a civil right as opposed to freedom? Freedom is what God gave you. God gave you the freedom to speak. God gave you the freedom of religion. God gave you the freedom of press. God gave you these freedoms because until the day you're called home, you have the freedom to do these things. Second Amendment, God gave you the freedom to defend yourself, absolutely. But God did not create the gun. The way in which you choose to defend yourself is a notion of right or wrong that our society wanted to preserve for all members of our citizenry. That's why the Second Amendment is the right to bear arms. That's why you have the right to trial by jury. Because God didn't create the jury is made up by man. But in order for a civil right to be a right, under our egalitarianism form of government, if you go to John Locke or Jacques Rousseau or any of these other philosophers of our system of government, they said that in order for a law to be legitimate, it must be just and equal. If a law does not apply equally to every member of our society, that cannot be a civil right, because a civil right must apply equally to every single member of our society. Yes, brother.
Therefore, the state of California has been infiltrated by a massive gang conspiracy in order to manufacture false enemies of society and then enslave them via the prison industrial system.
Yeah, so Thomas Jefferson, John Locke, actually, let me say John Locke, because John Locke is easiest in his treatise of government. So what John Locke said is he said that when the government reduces the people to a state of enslavement, right, that they are warring against the people, and thus the people have the right to no longer be obedient to the government and restore their original liberties. So we are at war against the government because the government is choosing to not follow the very basic, simple procedures and processes codified in the Constitution of the United States for the administration of justice.
Which also proves that business is just warfare by economic means. Not using direct violence, using indirect violence, via using these unconstitutional laws to target.
Yeah. So again, what I would say once again is that if I can give people $180,000 worth of education in one sentence, it is anything that is not the Constitution is unconstitutional simply by virtue of the fact that it's not the Constitution. Anything that's not the Constitution is by its very inherent nature unconstitutional. So when you go in and you want to argue a civil rights case, you can't mix and match state statutes or UCC or case law, because all of that is not the Constitution. Therefore, all of that is unconstitutional. So if you're going to argue a civil rights case, you go to the highest form of law. You speak it, right? And you don't come down off of it to fight down the weeds where the judges and prosecutors and attorneys all tend to win. That's why, if I could. So I spent 9 years in military special operations. I was a special operations officer in the Navy. Thank you. And so I spent 9 years in military special operations. There's a combat philosophy that whoever holds high ground has got a superior tactical capability, right? If you hold high ground, you're going to win, right? Because you've got to draw them up to you, and they can't fight the same level. I can shoot over the berm, but they can't shoot above the berm, right? So whoever holds high ground has a superior tactical capability over their enemies, right? So if the Constitution is the highest form of law, then my analogy is get up on that highest form of law. Get up on it. Don't come down off of it. You maintain your superior tactical capability. Because you see, what's going to happen is these attorneys are going to try to draw you down. They're going to say, okay, they're going to argue case law. I'm going to say that ain't law. Because judges make rulings. Judges can't legislate. There is no legislative authority for a judge to. We didn't delegate that authority to the judicial branch. Judges don't create law. Very simple concept. However, when judges create a ruling and then erroneously call it law, guess what? That would be unconstitutional. So when the state of Washington, for instance, back in 1874, when the Constitution of the United States, under Clause 1 of Amendment 5, says, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, that's pretty clear. You better have it indicted by a grand jury according to the highest form of law. However, State of Washington, Article 1, Section 26 of its inferior Constitution says, no grand jury shall be drawn or summoned in any county. Why is it that the state of Washington has a provision in its inferior state constitution that functions directly to the contrary of the Constitution of the United States of America? Why? That is because the state of Washington relied upon a judge-made ruling called Hurtado versus California, where the Supreme Court of the United States said, oh yeah, states, you don't have to do what the Constitution says. You don't have to have an indictment by a grand jury. You can charge bank. It's okay, California, because it was Hurtado versus California. It's okay, California, you don't do an indictment by a grand jury. That's all right. You don't have to. And so what happened there was the Supreme Court of the United States relied upon and sided with a state constitution and not the United States Constitution, and in doing so, they just committed a seditious ruling that they erroneously called case law. Because guess what, Supreme Court of the United States, you have no delegated authority to be able to legislate. You may not legislate from the bench. So when they did create a ruling and amended the Constitution of the United States in an other than lawful manner, contrary to Article 5, because Article 5 will tell you the way you should change the Constitution, and it cannot be done by judicial fiat. Judges do not have the authority to be able to amend the Constitution of the United States because all amendments to it must be done by an authentic act of the people in accordance with special and procedure of Article 5. Sedition is defined as the speaking or writing of words, such as law established, in order to cause disaffection to the Constitution to procure its alteration in other than lawful manner. If you attempt to change the Constitution in a manner other than what's prescribed by the special and procedure of Article 5, you have just created a seditious law. So, Supreme Court of the United States, when your predecessors, your despicable predecessors, you tell us we have to call honorable every day, when they chose to amend the Constitution of the United States in a manner other than what is prescribed, what you just produced was seditious, right? Done by traitors to the nation. And it was done in open court, for God's sake, which is the requirement for treason in the Constitution of the United States. So as long as the Supreme Court of the United States continues to proliferate this concept of fraud that was introduced in 1887 by the Supreme Court of the United States when they said you don't have to do an indictment by a grand jury, even though it's required by the Constitution of the United States, and then the state of Washington, the state of Oregon, the state of Connecticut, the state of North Dakota, the state of Oklahoma, the state of Florida, Georgia, California, when they decided to rely upon a judge-made ruling that was erroneously and unlawfully called law in order to establish their inferior laws, and then go out and enforce those, right? Direct their agents, the prosecuting attorneys, and judges to rely upon a state statute that directly abridges the fundamental rights of the people of the United States, right? Under the Bill of Rights and Constitution. Then guess what, states? What you did was unconstitutional because you relied upon something that was not constitutional to create your inferior laws. And when you did that, then that means that every single contract that you are creating based upon the reliance of an unconstitutional state statute that was created based upon the reliance of an unconstitutional judge-made ruling, it's all unconstitutional. Everybody, it's all unconstitutional. So all the contracts that you're creating are all unconstitutional because they derive from something that was not law, created by a branch of government that has no authority to legislate. This is a simple concept. But once again, let's bridge this across to familial. Let's see how children apply to indictments by a grand jury. There's a way to fight this, and it does not come by way of an unenumerated right. It comes by way of an enumerated right. An enumerated constitutional right is one that's written in the Bill of Rights. If it's written there, that is a facial constitution. That is a direct violation of the Constitution. And you have to, if you're going to challenge the Constitution out of the statute, you better find a facial violation. Because if you rely upon an incorporated violation, then that court, the Supreme Court, especially with the size of this, think about how massive this issue is. With CPS, 12 million children currently removed, stolen from their families. Think about how long this has been going on ever since the comic leasing days of the turn of the century. We have a lot of people that have been directly impacted by a state that believes that they can interfere with the familial unit and destroy it through government interference, even though the Supreme Court of the United States said in 1984, under Roberts versus the United States, that you have a right to have an intimate familial relationship with your family without government interference, found to be fundamental, protected by the First Amendment. So again, First Amendment are all your God-given rights. God gave you the right to speak. Until the day you're called home, you will continue to be able to speak, right? So therefore it is freedom of speech. The freedom of press. God gave you the right to be able to speak out against tyrants and think and develop your conscience. That is a freedom because God will allow you to do it until the day God calls you home. No one can take that away from you. That's why the first Amendment are all God-given freedoms. Freedom of speech, freedom of religion, freedom of press. That's also the reason why the Supreme Court of the United States and Roberts v. United States determined that your right to intimate association is protected by the First Amendment because guess what? God made you a mother. God made you a father. Until the day you're called home, you remain a mother or a father. Therefore, only God can take that from you. That's not a creation of the state. That is actually a creation of God. And therefore, no state has the right to be able to bridge it because it's a freedom of intimate association. State can't take away your right to have a relationship with your family, right? They can't do that because that's a freedom. Freedom of speech, freedom of religion, and freedom of intimate association. It is a fundamental constitutional right protected by the First Amendment. Incorporated in 1984 by the Supreme Court of the United States. But we cannot argue the right to intimate association because it's not enumerated. That's why I had to go with an enumerated right. That's why I identified indictments by a grand jury. That's why I'm using prisoners because, once again, every one of these prisoners is someone's child. And I've talked to tens of thousands of these mothers and fathers across this country. And I don't care if you guys don't like them. I'll tell you what, those parents love those kids. They love them a lot. They would like to see them back home with them, getting the love that they need to be able to heal from the trauma of this system that has fucking destroyed their lives, right? That's what we need. And so, yes?
You said that there was 2 countries that were getting rid of it.
Oh, yeah. Yeah, so the first is Sweden. So Sweden is getting ready to shut down its final prison right now. Getting ready to shut it down because Sweden chose a restorative-based justice system as opposed to a punitive-based justice system. So what we do here in America is we take hurting people and we put them into a more hurtful situation so that they can become a better criminal, right? Yes?
What's the second one?
Second one is going to be Israel. So Sweden, in Sweden, if you are a serial killer, like the worst of the worst, like, oh my God, this is the worst behavior of all. In Sweden, if you're a serial killer, you get dressed every day and you go to work. And you come home to a house and you got officers or corrections people that care about you and that take care of you because the worst, most aberrant behavior within our society, and this is my forensics degree, because once again, you guys, I'm 100% qualified to be able to speak on this issue as well as an expert. Because I do have a master's in forensics from George Washington University, the most successful university in the United States. I graduated with 398 GPA on the South Lawn of the White House. I can speak on criminality, all right? So the worst of the worst, the most aberrant behavior that we have in our society, these are people that they themselves were victims of some of the most, of a level of depravity and abuse that's beyond even our own understanding, right? Child abuse. These are people that had been victims of attempted murder of their own selves by the very people that were there to protect them and take care of them. Most of these aberrant behaviors, these are people that were once a child that was absolutely hurt, that they attempted to kill by those very people because they didn't get the love that they needed from their mother and father. Yes, ma'am.
I would say nobody's born a criminal, so how do they become a criminal? I used to work in the public defender's office, but what I see happening is there's no more industrial prison complex, especially on the West Coast, because they don't want to pay to fund a building where you got to pay for nutrition, for heat, so what they do on the West Coast, which I feel like is in some elitism, is they're decriminalizing everything. Well, people who need help, so now everybody's on the streets, whether they're an addict, mentally ill, criminal, a combination of all, and it becomes this way to funnel the money into the nonprofits that our government is like giving these, here's $5 million to this nonprofit. It's supposed to help these street people, get rehabilitated. And where's the accountability? So like the whole idea of like the prison industrial complex and locking people down, that's gone, at least on the West Coast, or at least in Oregon. Maybe California, there's still like real.
Definitely still in California.
Huh?
Definitely
Still in California,
Yeah.
right? But I always feel like I always have to say this, is like On the West Coast, we've got the 3 blue states, right? California still got money, it's Cinderella, right? We're the 2 ugly stepsisters up here, Oregon and Washington. We don't have the money, California's got the money, but I mean, what we see happening and what I say is like, this elitist attitude is like, they act like they have empathy and they're gonna lead these people who've been, abused, turn to crime, turn to drugs. It's empathy, but we're gonna let them die on the streets, so that's apathy. And it's just this trifecta of like corruption.
Yes, they act like they care, but they don't.
Yeah, exactly, right.
And I appreciate, I would agree with what I've seen across Washington and Oregon for sure. But I will say that the East Coast is not the same. The East Coast is still imprisoning, and when you look at, there's some drawings of the, and I don't want to throw the numbers out but I want to say that there's like 930 prisons that have been built in the last 20 years, but then something like 120 schools that have been built.
Right.
So we're like 10 times as many prisons as there are schools that are being built, right?
Mm-hmm.
And so, but the concentration of those prisons are along the East Coast and down the South.
Right.
But that's also where the prison industrial complex came from. I mean, if we're talking about slavery and the slavery institution, which is all that we're talking about, I mean, that's what this justice system is. Justice is a term that's created by slave owners to preserve, protect their property. And we gotta be honest with that. We gotta say, this is the truth. If you have a degree in Juris Doctorate, if you have a degree in making a person into a criminal, you have a degree in making a person into a slave. Because the 13th Amendment equated the term slave and prisoner. They mean the same thing, right? And once we understand that basic fundamental issue, then we can start to resolve this. Because we gotta get these attorneys, in order for me to be successful in what it is I'm doing, these attorneys are going to have to admit that every single thing they've done and their predecessors have done it completely without force or effect, because they were trained to follow administrative law. That is a bar, that's an English bar concept. In England, the king creates the law. King creates the law. They have monarchy. King creates the law. Therefore, he did delegate his authority for his judges to speak the law. When a judge in England speaks the law, makes a ruling, that is law in England. Because the king did delegate his authority to them, therefore case law applies to English common law doctrine, right? That's an English doctrine. But not here in America. We the people did not delegate the authority for judges to speak the law, because all legislative power is vested in the Congress of the United States, consisting of the Senate and House of Representatives. Here in America, we did not delegate that. That's Clause 1, Article 1 of the Constitution. All legislative power, which is all power to deal with law, create, amend, destroy. Any legislative power is vested in the Congress of the United States, consisting of the Senate and House of Representatives. So we did not say to the judges, you get to create law. We did not say to the executive branch, you get to create law. We said we are reserving that power to ourselves. We're not delegating it to anyone else. We are reserving it. So that becomes a restriction against the other branch of government. So when a judge does create a ruling, right, that ruling is supposed to be consistent with positive law, because judges are tethered to positive law. They don't get to legislate from the bench. So, again, going back to this familial issue, I'm using prisoners. I'm using the indictment by a grand jury issue to get heard by that court. 700,000 people currently in prison here in America on direct facial constitutional violations. Every single one of them will have a void judgment as a result of the work that I'm doing. Every single one of them. Because the states did not follow the proper procedures and processes codified in the Constitution for the adjudication of that crime. There's 2.9 million people currently in prison here in America. 2.8 million of them were not present in the grand jury proceeding to confront the hearsay accusations that are against them. That is a proceeding that exists for the benefit of the accused, to protect them from hasty or malicious charges by the prosecutor, who just so happens to be the very person that is denying them the right to be present in that proceeding to protect them from the prosecutor. That's an abusive process. It's also a crime. It's called conspiracy to obstruct justice. Conspiracy to obstruct justice derives from Title 42, subsection 1981. That is a civil statute that says that all persons within the jurisdiction of the United States shall have fairness and benefits of all laws and proceedings. Fifth Amendment is obviously a law created by the United States, therefore protected by 1981. Grand jury is a proceeding created by the Fifth Amendment, therefore it's also protected by 1981. So all persons within the jurisdiction of the United States shall have fair and equal protection of the Fifth Amendment in the grand jury proceeding. So in order to enforce that civil law, we had to create an enforcement statute, Title 18 enforcement statute. Because in order to enforce the civil law, you got to have an enforcement statute. The enforcement statute is conspiracy to obstruct justice. When two or more persons conspire for the purpose of depriving any person of any rights when two or more persons conspire for the purpose of depriving any person to prevent any party in any cause from participating in said cause commits that crime. So when the prosecuting attorney conspires by and between the accuser to deny the accused the right to be present to benefit from the very proceeding that exists for their protection from the prosecutor, the crime of conspiracy to obstruct justice has occurred. And as a result of that criminal offense, that voids and renders unlawful the indictment itself, right? Because if the indictment exists as a result of a violation of law, if government broke the law to secure the indictment, that indictment is unlawful. Because any act unlawful at the beginning cannot become lawful over time or by subsequent legislation. That is a maximum law. So if government committed a crime in order to secure the indictment, that indictment is unlawful, which means that the arrest is unconstitutional because there is no indictment in place before holding someone up for that crime, which means that anything that derives from that arrest must also be unconstitutional because it is all tainted by the illegality of the way in which it was obtained. So if the arrest is unconstitutional because you didn't have proper documentation, then that means the plea bargain is unconstitutional, that means the trial is unconstitutional, that means the sentencing is unconstitutional, that means the fines and fees and post-release are all unconstitutional because it is all fruit of the poisonous tree derived from an unconstitutional arrest. Okay? So that's the indictment issue. But that's enumerated, written within the Bill of Rights. Enumerated. That's very, very simple. So right now today, what I'm using to get into the court is I have 2.9 million people standing behind me who all have rights enumerated and protected by the Constitution of the United States. And standing in front of me is one Supreme Court of the United States. Standing behind that court is 40,000 traitors who are following inferior state laws to deprive these people of rights that they're guaranteed by the supreme law of the land. Let me ask the question, who's going to win this war? Who's going to win? 40,000 judges, 40,000 criminals, or 2.9 million people? I think we know where the numbers are at here, right? What stands in front of me has no power against what stands behind me. The moment that what stands behind me steps up and realizes that through me, they can find a void and a pathway to a new life, the moment that they realize that and understand the power that I have from them, we will defeat 40,000 criminals. They don't stand a chance against what stands behind me. And when we bring in the familial unit now, those numbers are going to go up exponentially. Because every single child that's been taken from their mother and father, the love that they're entitled to, the love that God created for them to become a person, right? And not a monster. The moment that government interfered with your relationship to have with your child, right? Or with your father, with your mother, with your cousins, your aunts, your uncles, your grandparents. The moment government decided that they knew better how to raise the family than the family itself knew, what they've done is unconstitutional because the Supreme Court of the United States in 1984 said that you have the right to have an intimate familial relationship with your child without governmental interference, and your child has the right to have an intimate familial relationship with you without governmental interference. Yes, ma'am?
So I'm curious, and this goes across family law, criminal law. So when you try to do a Freedom of Information Act and you try to actually get emails pertaining to the case, pertaining to the legal professionals working with the judiciary, you're denied, or how do you even trust? Are you even getting like a fraction of what is being said electronically? Like what can you use? Because that's where I think they hide behind is this electronic blanket of, and then if a child's involved, they try to say, oh, it's to protect your child, but if you're the parent, how can you not get access to these emails that would incriminate them all to show the collusion?
Yeah. Well, let me just tell you a little bit of my history, my background. And I'll answer that question through this.
Yeah.
So I'm a believer. I hope that you guys know that. I hope that it stands and it resonates, because if you guys don't know I'm a believer simply by the words they say and the way I act, then maybe I'm not. Maybe I need to work on my faith a little bit. But I'm a believer. I believe that every single thing I've done, every single step, everything God has created me to be is exactly who I'm supposed to be. I got a master's in forensics. I specialize in forensic accounting. This is accounting law. And within forensics, I also specialize in forensic video analysis, right? Which is all about creating patterns within the image, right? But I also have a master's in information security, which is the protection of electronic data, which you're referring to. And then I have a master's in substantive law. So when it comes time to actually move forward, which is, I'm not concerned about these transcripts. A lot of people are like, oh yeah, but they're changing the transcripts, or oh, you need to go out and get the transcript data. No, you don't. I'm gonna tell you guys right now, court, I've got Secret Service and FBI dossiers, so I do like to speak directly to that audience because they're watching it. But I want to say to you guys right now that I'm not concerned about you guys erasing it or changing it on LLI or LII or one of these other things, because you know what? When it comes to electronic data, there's a base file. And that base file is the most, it's in its original form. So when you assholes decide to log into an information system through your user login, and then you decide to alter the transcripts, right? There's data that's attached. I have the base file. And when it comes time for me to actually investigate this, because God has made me an expert in forensics, because God has made me an expert in information security, you guys are fucking with the wrong person here, okay? So I'm not so concerned about the integrity of the data, because what we have to do right now is we got to get enough attention on this so to where we can actually get into that system. But I guarantee you, they're not able to hide this. If Hillary Clinton has to use her Yahoo account because she, as the Secretary of State, cannot bypass the redundant server arrays that we have to protect the integrity of the data, then you know what? None of these little peon fucking nobody judges here across the state of Oregon, state of California, or any one of these state judges that are nobodies and nothings, they're not going to be able to hide their criminality. And I guarantee you that when we get into this system, that whatever information you need to be able to show the crimes that were committed against you and your family, we're gonna get that. We're gonna have that. It will be preserved. I'm very, very confident, and that's why I don't worry about collecting the information, right? I don't need transcripts, because at the end of the day, there's gonna come a point in time when I'll have access to that data. But right now, you know, Gandhi, he said that it's not the oppressor that needs to hear the truth. They already know it, they're busy concealing it. It's the oppressed that needs to hear the truth, not the oppressor. This whole tour, everything I'm doing over the next 37 days, this is about raising awareness for the people, right? And I hope that the people start to understand this. You know, we have a good turnout today. It's not as big as we would like, but I'm praying that as we move along here, as we get more and more of these days together, that you guys are going to come out, you guys are going to show your support, you guys are going to rally together, and we're going to be able to finish this in the next 37 days, because that's what this is all about. Because this is an issue that people in the United States need to be made aware of. I'm not going to mess with the courts. I'm not going to come into their battlefield and play their games, play by their rules when they themselves don't adhere to them. I'm not going to go to a criminal and say, hey, criminal, stop committing crimes, because you're a criminal. You know, if I play with a scorpion and it stings me, I'm not going to blame the scorpion. I knew what it was. If I play with a criminal and I follow the rules that the criminal has established, I know the criminal's not going to follow it, so why would I do that? That's why this is all about asymmetrical warfare. This is what I was trained to do in the military. That's why I have special operations military. This is what I do. I fight asymmetrical warfare. That's why I'm out here talking to the oppressed, bringing the knowledge to the oppressed so that we can overcome the oppressor, because the 40,000 people standing in front of me doesn't stand a chance against the 330 million people that can be standing behind me. Right? 2.9 million people standing behind me that had rights that were guaranteed to them by the supreme law of the land, that 40,000 criminals in front of me have all broken. The law. Who's going to win? We have 330 million people potentially that could get behind me to destroy 40,000 criminals. That's the case, that's the issue. What stands in front of me has no power against what stands behind me. And once we understand that concept, once we realize that we can argue one single issue for 330 million people, even the people that don't know that they needed a protection, when we argue the same issue, government, do you have the right to be both accuser and judge? Does CPS, an agent of the state, have the authority to bring an accusation against the mother and father, and then through a judicial officer of the exact same body of men, make a decision to destroy and interfere with the familial unit in violation of the Constitution of the United States of America? The answer is no. Absolutely not. Right? But we got to start with an enumerated constitutional right. We have to find something that's been broken that was written in the Constitution, in the Bill of Rights, to use that as a mechanism to be heard. But once I get there to the court, we are going to be arguing on behalf of the people of the United States for the fact that can a state be both accuser and judge in the same cause? The answer is, without a doubt, 100%, infallibly, no. Preserved by Article 3 of the United States Constitution, where it says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. Again, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. So if a state is a party in a cause, that state cannot be judged in the cause, and that judge has a constitutional obligation codified in Article 3 to recuse himself, and failure to do so means that that court is acting without jurisdiction because that judge has no authority to be the judge in the case because he has a constitutional obligation to recuse himself because the Constitution has said that in all cases in which states shall be party, the Supreme Court shall have original jurisdiction. Now, maybe I'm interpreting that wrong. Maybe I'm just reading that improperly. Let's see what the founders had to say about that, right? Because if we want to understand why the founders' forefathers wrote the Constitution in the manner they did, we would typically go to the Federalist Papers, written by John Jay, Alexander Hamilton, James Madison. These are three of the founding fathers of our nation. These are three people that sat in the Constitutional Convention that created our Constitution, right? So if we want to understand why they wrote Article 3 in that way, in all cases which a state shall be party, the Supreme Court shall have original jurisdiction. Well, let's see what James Madison had to say about it. James Madison is considered the father of the Constitution. In fact, Justice Gorsuch right now, United States Supreme Court, he says James Madison is the sole authority for all things constitutional, right? We go to him to determine. He wrote the Constitution. He wrote the Bill of Rights. And Gorsuch even says this right now today. If we want to know the original intent of Article 3, let's see what James Madison had to say. James Madison wrote the Federalist, number 10. New York Packet, November 23rd, 1787. It was the article that was titled "The Union as a Safeguard Against Domestic Faction and Insurrection." And in the article, Mr. Madison said, "No man is allowed to be judged in his own cause because his interest would no doubt bias his judgment and not improbably corrupt his integrity. With equal, nay with greater reason, a body of men are unfit to be both judge and party at the same time. No man is allowed to be judged in his own cause. And a body of men are unfit to be both judge and party at the same time." So what he was getting at there was that when the body of men that make up the state has a lot of different parts, prosecutors, attorneys, judges, law enforcement, CPS, that body of men cannot be presumed to be neutral and biased when it acts as the accuser and the judge. Therefore, that body of men must recuse itself from being both accuser and judge. If the state brings an accusation against you in one of its cases, then it must recuse itself from acting as the judge in that case. And so that's what James Madison said, directly attesting to why they wrote Article 3 in the manner in which they did. But you know what? Maybe I still got it wrong. Maybe I'm interpreting that improperly. So you know what? There's another author named Alexander Hamilton. Alexander Hamilton wrote the Federalist number 80. Federalist number 80. And in the Federalist number 80, what Alexander Hamilton said, he made two comments in the Federalist number 80. Guys, go out and read it. Okay? Two comments that has to do with this particular issue. One is, he said the federal judicial authority of the Union must extend to all cases between a state and the citizens thereof. Again, the federal judicial authority of the Union must extend to all cases between a state and the citizens thereof. So if there is a dispute between a state and the citizens within that state, the federal judicial authority of the union must extend. In other words, United States Supreme Court, federal judicial authority must extend if it is a dispute between a state and the citizens of that state. That's the first thing that he made reference to in Federal Supremacy. The second reference that he made in Federal Supremacy is he said state tribunals cannot be presumed to be neutral and unbiased when they speak for themselves. No man ought certainly be a judge in any case in which he has the least bit bias or interest. Again, state tribunals cannot be presumed to be neutral and biased when they speak for themselves. Thus, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. If there's a dispute between a state and the citizens of that state, the state may not be judge in that case. That's number two. But you know what? Maybe I still got it wrong. Maybe James Madison and Alexander Hamilton, maybe the two of them is not enough. Maybe we need another witness. Because remember, Scripture says he needed 2 or 3 witnesses to all matters. So let's see if there's a third witness. Well, that would be John Jay. John Jay was the third writer of the drafter of the Federalist Papers. He was a member of the Constitutional Convention. And what John Jay said, right? He didn't make a statement within the Federalist Papers attesting to this, right? But he was the first Chief Justice of our Supreme Court of the United States. He did make a mention to this in the ruling Martin versus Hunter's Lessee. Because in Martin versus Hunter's Lessee, United States Supreme Court, he said that the Constitution has presumed that state interests, state biases, and state prejudices might from time to time obstruct the administration of justice by state judges. Therefore, it is the case and not the court that grants original jurisdiction to the Supreme Court. The Constitution presumed that state prejudices, state biases, and state interests might from time to time obstruct the administration of justice by state judges. Therefore, it is the case and not the court that grants original jurisdiction to the Supreme Court. Because the Constitution says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. So when the state, or even the Supreme Court, when the Supreme Court says to you, oh, you got to go and exhaust remedies with the state, you got to get a decision from the state before you can come into the federal court, you're going to say, oh, bullshit, we do. Because it's the case and not the court that grants jurisdiction to the Supreme Court. It is not up to the state to determine whether or not they are granting you jurisdiction onto the Supreme Court. Because remember, jurisdiction exists before that court. The people of the United States, we in our sovereignty, created the Constitution. The Constitution then created jurisdiction. Jurisdiction then creates the court. The court then creates the agent. So the agent is actually the lowest on the totem pole. We people are the highest on the totem pole. So jurisdiction exists before the court. Therefore, no court can grant itself jurisdiction. No court can take jurisdiction because jurisdiction is statutorily imposed that exists before the court has the authority to take action. That's why anytime the court acts without jurisdiction, anything it produces is void, wholly, without force or effect, referred to Civil Rule 60b-4. Because the first duty to that court is jurisdiction. Absent jurisdiction, that court is not a court. Absent jurisdiction, that agent is not an agent. Because any action of a court that lacks jurisdiction is not lawful because it's against the law. That's why the Supreme Court came out last February, and said that the difference between a claims processing rule and a jurisdictional rule, claims processing is an appeal. File a claim, that would be claims processing. A jurisdictional rule would be jurisdiction. Right? So the difference between a claims processing rule and a jurisdictional rule is that a jurisdictional rule can never be waived, can never be forfeited, because it comes as the first duty to the court. Before that court can be a court, it must have jurisdiction. Absent jurisdiction, anything it does is completely without force or effect, because that agent cannot be an agent of the court unless the court is a court. That's why what we're doing here is we're challenging the jurisdiction. That's exact. We are going to the court that has original jurisdiction, Because in all these cases, whether it's CPS, whether it's a criminal matter, whether it's a guardianship, all three of those, does the state have the authority to be able to oversee this dispute in which an agent of the state is a party to this cause? The answer is no. So when we challenge the authority of the court through the jurisdiction, then anything created absent jurisdiction will automatically be rendered void. That's why I'm not fighting these individual CPS cases. That's why I'm not fighting these individual criminal cases, is because there's too many of them, guys. I'm challenging the law that the state created in violation of the Constitution of fundamental rights in order to void them, because if I can show that the law that was created by the state, that was created because of a judge-made ruling that was erroneously and unconstitutionally called case law, even though judges don't get to create law, when I destroy the state law, everything that was created relying upon it, all the contracts, whether it's an adoption, court didn't have the authority to adopt a child. Whether it's a TPR, court didn't have authority to TPR you. Whether it's a criminal matter, state didn't have the court to arrest you. Whether it's a guardianship, state didn't have the authority to put you into that conservatory. All of these are all unconstitutional because they're all contracts that are created relying upon something that is not constitutional when the state decided to exceed the power authority statutory conferred upon it, when they went to a judge-made ruling and said, judges create the law, even though we didn't delegate that authority to do so. Yes, ma'am.
Okay, so what you're saying about the conflict, right? You can't oversee and then have another extension of the court, a vessel of the court, whether it's CPS, it's just a conflict of interest. So take that even further, right? Because everything's diversified, everybody has, greed is king in this country sometimes, or certain jurisdictions. What about now what we see, and it's state by state, it's county by county, depending on their local rules. Not every state has supplemental local rules. We do in Oregon, which means in Oregonian in Washington County, Oregonian in Multnomah County, they don't even know, they can't even talk to each other because there's supplemental local rules. So what about these other extensions? Like we talk about family court. So the judges are now, they're ordering not just CPS to be in the family's life, but family court coordinators, or parenting time supervisors, or child attorneys. So they're all extensions. So is that the same conflict? I mean, they don't have like a true line, but like, what would you say there? Like maybe they're not truly like a government entity like CPS, but they have like a dotted line to the judge.
Judge has no authority to be able to create an order. If the agent creates an order through a court that doesn't have the authority to be able to be a court because it lacks the jurisdiction, then those orders are void.
Which means the state of California owes me not one but 3 votes.
And I want to be clear on something here, guys. I'm dealing with the first half right now. So the reason why most civil rights cases fail in procedural default is because most people don't understand where their rights come from. Rights always derive from another's duty to act. Guys, this is extremely important. So watch this and listen to what I'm about to say here. Rights always derive from another's duty to act. This is the doctrine of duties and rights. So where there is no right or where there is no duty, there cannot be a right. Okay? Now there are duties that exist that do not have corresponding rights, such as duty to God, duty to spouse, duty to country. I don't have any rights that exist on my duty to obey God. God tells me to do something, I got to do it. If I don't do it, then guess what? There is no rights that I have that result from my obligation to obey God. But there cannot be a right that exists without a corresponding duty. So what does that mean? A duty is an obligation. So a law creates obligations. So I have an obligation not to kill someone. I have an obligation not to speed my car. I have an obligation not to assault someone. I have an obligation not to steal from someone. These are obligations that the law created. So when we identify a right, such as, I want the right to live. I don't want to die. I don't want somebody to kill me. So what we do is we create a law. And that law creates an obligation for me to not kill someone, right? Which means that if I break the law, if I breach my obligation, I kill someone, then their right to live has been violated. So their right derives from the law. So you cannot claim that your rights have been violated until you first show that someone had a duty, there was a law in place, and they broke the law. So all of these instances here now, let's take these judges for instance. When you are told to go to a judicial misconduct board, file a misconduct report, right? File it to judicial. Then they come back and they say, oh, the judge made an error. He made an error. When error is not a crime, but treason is. Error is not a crime, misconduct is. But let me ask a question, okay? When you go and you have something stolen from you, do you go to a robbery misconduct board to file a claim? Right? You go to the police, right? You file with law enforcement, a criminal complaint, you say, hey, a crime was committed against me, and then they deal with it. So why are you following a different order for a judge's crime? It would seem to me as though if a judge broke the law, you would need to go to law enforcement to enforce, but instead you are directed to go to a judicial misconduct board, where they're going to investigate it, not law enforcement, but judges, administrative branch. Remember, the administrative branch is not enforcement, therefore they have no authority to be able to hold that judge accountable for his crimes because you didn't go to law enforcement. But just as I said this morning in the live, when I went around the country now, I've served 44 state attorney generals. 44 state attorney generals with actual crimes that are being committed by their agents when the prosecutor chose to rely upon an inferior state statute that deprives the person right guaranteed by the Constitution of the United States of America. When they did that, what happened is that they broke the law. It's deprivation of rights under color of law. Title 18 subsection 242. So Title 18 subsection 242 says, any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of rights assured by the Constitution, commits that crime. So again, any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of rights assured by the Constitution, commits that crime. So in the state of Oregon here, decided that they were going to create a statute in their inferior constitution and then direct their agents, the prosecuting attorneys, to go out and enforce that statute. That would mean that when they did do that, that would be an unconstitutional act because the prosecutor swore an oath of fidelity with the Constitution of the United States. So they had committed the crime of deprivation of rights under color of law. They believe that the inferior state statute is in fact superior to the Constitution of the United States of America. And I will tell you that if you want to know what abuse of discretion is, you would go to the Circuit Court Handbook, United States Circuit Court Handbook. The Circuit Court Handbook applies a two-part test to determine abuse of discretion. The first part is, did the judge rendering the decision, did he apply the incorrect test? I'll tell you what that is in just one moment. But the second part is, any erroneous view of the law is an automatic abuse of discretion. Again, any erroneous view of the law is an automatic abuse of discretion. An erroneous view of the law is that in the judge's legal contemplation, that a judge-made ruling is superior to the Constitution of the United States of America. That would be an obvious erroneous view of the law. Therefore, an automatic abuse of discretion has in fact occurred. According to the United States Circuit Court Handbook, according to Blackstone, 2009, any time that a public official abuses any discretionary authority with which they're invested in law, they commit 3 crimes. 3 crimes automatically. One is extortion, because they are compelling a result through illegal means. Right? They are bringing about a result through an abuse of discretion, through a breaking of the law. The crime of extortion has occurred. Bringing about a result through illegal means. The second crime is perjury, because they made a promise that they would do something, a future outcome. They made a contract with people. And they've already implicitly invited punishment in the form of perjury should they fail to fulfill such a promise. Now, perjury is a violation of public trust, meaning that you can no longer be trusted by the public to fulfill your obligation. You've already implicitly invited punishment. You've already said that I will be guilty if I don't do what I promised to do. Which is why public officials have a crime known as per se. Per se meaning that I don't have to prove that they intended to breach their obligation simply by virtue of the breach. All elements of crime have been met. Okay? All elements. So if you make a promise, judge, if you make a promise, prosecutor, you say that you'll do something, a future outcome, and you fail to do that, I don't have to prove that you intended to do it. All I gotta show is that you were supposed to do it. And you're already guilty. You've already invited punishment. You've already agreed to be guilty of that crime should you fail to fulfill such a promise. That's why public officials have a per se crime. Now, another interesting thing is that when you look up per se and the definition of it, it says crimes that are self-evident. Self-evident. Now, that's an interesting word as well, because we find in the Declaration of Independence, in the preface, it says that we hold these truths to be self-evident. Self-evident. So per se crime is self-evident. We hold these truths to be self-evident. The evidence is interpreted by self. I can see right there. It says right there, no person shall be held to answer for capital otherwise than prescribed unless I present me more indictment to the grand jury. Where's the indictment by grand jury before arresting me and holding me over for a capital or crime? Self-evident. Per se. Already implicitly invited punishment. Crime of perjury. Violation of public trust. Can't be trusted to hold your office anymore. These judges, they already know that they're in a lot of trouble. They already know that they're in some deep shit right now. Prosecutors already know they're in some deep shit right now. Right? Because their crimes are self-evident. Their crimes are per se. They've already implicitly invited punishment in the form of perjury, form of extortion, and the form of oppression. Because oppression is a third crime. Because oppression is the unequal application of the laws by a person in position of authority. So that more than that judge, in that family court case, he had two people that came into the same courtroom. Father and a mother. And during that hearing, he said, you know what? I'm not going to interfere with this person's right, but I am going to interfere with this person's right. And as a result, he's applying law unequally. And that is the crime of oppression. Because he's abused the discretionary authority with which he's vested in law to deny one party a right that he must protect and to deny the other party the same right that he must also protect. And he chose to apply the law unequally amongst like members of society, thus a violation of the 14th Amendment. So 3 crimes are automatically the result of any person that violated, that abused any discretionary authority with which they are vested in law. Circuit Court of Hamburg. Any erroneous view of the law is an automatic abuse of discretion. So when the judge relies upon the lowest form of law, called judge-made ruling, that they erroneously call case law, and you believe that that is in legal contemplation superior to the highest form of law, the will of the people, the common law, the Constitution of the United States of America, that is an obvious erroneous view of law. Therefore, an automatic abuse of discretion has in fact occurred, and if you have committed the crime of perjury, you are discharged from your office in accordance with Article 3. So I want to bring your attention to 2 things here. Because they say, oh, well, you gotta take them to a trial. No, you don't. No, you don't. Public officials don't get a trial. They don't get a trial. Because Article 3 of the Constitution of the United States, again, Article 3, it says, the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in the state where its crimes have been committed. The trial of all crimes, with the exception of impeachment. Why is impeachment not on the list that requires a trial by jury? Because impeachment is a per se offense. We don't have to prove that they intended to breach their obligation. There is no finding of facts, public officials, attorney generals. You're not going to get a jury because the trial of all crimes, with the exception of impeachment, shall be by jury. All we got to do is show that you had an obligation, you made a promise, and you failed to fulfill that promise, and now you're guilty. And you've already implicitly invited punishment should you fail to fulfill that promise. So I would suggest that you guys pull your head out of your ass and get behind this, because this train is coming your way real soon here. So that's the first thing. There is no finding of facts. You don't have to prove that you intended to do it. All we got to do is just show that you had an obligation. You failed to fulfill that obligation, and now what you produced is unconstitutional because you have abused your discretionary authority with which you're invested in law and violated the trust of the people. And now the second one that I want to bring up is also within Article 3, because it says the judges, both of the United States and of the several states, shall maintain their office while in good behavior. Good behavior. Good behavior is defined by blacks as the avoidance of criminal behavior. So according to the Constitution, the moment you engage in criminal behavior, judges, you are no longer fit to continue your office, thus discharged, which is why Article 3 says the trial of all crimes, with the exception of impeachment, shall be by jury. You do not get a finding of facts. There is no trial by jury. If you break the law, judges, if you commit the crime of perjury, which is the violation of your oath, if we show that you had an obligation to the people, delegated authority, and you abuse that discretionary authority by breaking the law, then guess what? You're done. You're cooked. It's over. And everything that you produce is fully without force or effect. Guys, this is the reason why fraud vitiates any action of a court. If fraud is introduced by a court, state court, federal court, if fraud is introduced, until that fraud is removed, everything that that court does is fully without force or effect. Which is why the Supreme Court of the United States must address this issue. Because there isn't a single state or a single court in the country that is producing a lawful outcome. Because until the Supreme Court of the United States comes in and corrects the unlawful, unconstitutional, seditious rulings that their despicable predecessors put into place at the foundation when they removed in 1833 the fundamental rights of the people of the United States by removing the Bill of Rights and putting into place their rulings and say, oh, we're going to be able to create our own law. Judges make rulings, judges don't make law, but when you created the ability for judges to legislate, create case law, and you put that case law at the foundation, thus removing the fundamental rights of the people, the Constitution of the United States, and then directed all these states to follow them, the highest court in the land made a seditious ruling and said that we don't follow the Constitution. State courts, you don't have to follow the Constitution. You just have to follow our judge-made rulings. And when we create the ruling, that is the law. And unfortunately, once again, Supreme Court, you don't get to create the law. But when you did that in 1833, and you directed all the courts in the country to follow your rulings that you erroneously and unconstitutionally called law, then that means that all of these courts across the country are following something that is not the Constitution. Something that is not, and as a result, everything they're producing is unconstitutional. Until you come back and you correct the despicable rulings that your slave-owning and slave-trading predecessors, your despicable, disgusting predecessors put in place, Taney, Wade, Marshall, the destruction that our country is experiencing today, the breakdown and fracturing of our nation, is on your hands. You're responsible for it, 100%, Supreme Court, you are. And as long as you continue to ignore this, Mr. Roberts, Mr. Thomas, Mr. Alito, Mr. Kavanaugh, Mr. Gorsuch, Miss Sotomayor, Miss Kagan, as long as you continue to ignore the despicable and unconstitutional seditious rulings that your predecessors put into place, you're a part of it. You are a part of the conspiracy. You are advancing the conspiracy under your authority, and every single one of these crimes that's sitting in this box, as well as 8 other boxes that we have, full of actual criminal affidavits from actual criminal victims across this country, you're responsible for every single one of them. And how many of these trials for these 500,000 crimes that are capital in nature, that are as prescribed by law, punishable by death, how many of these are you going to get through before you're going to say enough? All I'm asking is, you've got 37 days left. 37 days left before I return to Washington, D.C. with this evidence in hand, showing your collusion and complicity within a criminal conspiracy to undermine the laws of the United States because you're refusing to recognize and enforce the one thing that your institution was established, created, in order to preserve, protect, and defend. And if you're unwilling to do that, then I guarantee you that the people of the United States will not be forgiving. We will not be docile. We will not permit you to continue to break down and destroy our families. We will not permit you to continue to rob us of our money and our property. We will not allow you to continue to bring us into fraudulent proceedings in front of someone that has no authority to exist, in a building that has no authority to be established, because it's all in violation of the will of the people. It's all in violation of the very simple procedures and processes of the contract that we created and gave you government, said governments in accordance with these procedures. You may not interfere with our family anymore. You may not interfere with our relationships anymore. You may not take our property for public use without just compensation anymore. So, just as our founding fathers said, the very right and duty of the people to establish government, presupposes the obligation of every individual to obey the established government. George Washington never got involved. When government has an obligation, and that obligation is to preserve, protect, and defend the Constitution, to operate and consistent with the will of people, our right and duty to establish government presupposes the obligation of us to obey such established government. If you government are governing us inconsistent with the way in which is prescribed, then just understand we have no requirement to be obedient to such government. So as long as government is acting unlawfully in the beginning, and what they're producing is unlawful, any act unlawful at the beginning cannot become lawful over time or by subsequent legislation. So all these contracts that you're creating, removing children, adopting them, TPR and family relationships, mothers and fathers, every contract of enslavement that you're putting in place, every agreement to put a person into the conservatory and the guardianship, all of these are all without force or effect. They're all void completely because you don't have the authority to do any one of these, because they are all in violation and conflict with the one thing that was created or that was established to create you, your office, and grant you your authority. Absent the Constitution, none of you have any authority. Absent the Constitution, none of you have any power. Absent the Constitution, none of you have an office. So you must obey the Constitution of the United States. If you do not, then everything that you produce is void. Yes, ma'am.
So, I'm looking at this affidavit, and I know we're looking at CPS, but I really feel like there's an extension of this, because what I was saying before is the family court has especially become an industrial complex. It's a money machine. So all these extensions, I just feel like this could be rewritten because, and it's a movement across America, and I think that it went to the Supreme Court about parenting time supervisors. Parents who, not even charged with abuse, are having to pay to spend time with their children. They have to pay somebody to watch them to spend time with their children because somebody, the other party, accused them of something. They never had their day in court. So I almost feel like, could this be extended? Because they are orders from the court of all these legal vessels of the court that just continue this, conflict, continue this entrapment, continue their, government into your business. But it's not necessarily CPS. It's a supervising parenting time supervisor. It's a parenting time coordinator. It's a it's like, and they're all orders. So could that be?
Yeah. So my answer to that is that this is a criminal affidavit.
Right.
Criminal affidavit identifies material facts. Okay.
Right.
It's not a criminal investigation. It's not a criminal complaint. The
Right.
next step is a criminal complaint, and a criminal complaint leads to now an investigation. An investigation is going to say, okay, this person was involved, and this person was involved, these people were involved, and but what I'm trying to do is I'm trying to get everybody into the same procedural situation so I can litigate everyone together.
Mm-hmm.
Because what we're doing is once we get the petitioners into the same procedural situation, then if one petitioner overcomes the procedural situation, all petitioners overcome. You're absolutely right. There could be hundreds of thousands potentially additional named individuals within that, agencies and everything. But unfortunately, that wouldn't apply to every single situation. So what I'm trying to do is I'm trying to get people down to the most basic. Okay, someone portraying themselves as an agent of the state interfered with your right to have a relationship with your child. I don't know who that person is. That's why they're not called out. And there's a lot of instances in which the person doesn't know. But no matter what, someone interfered with your right. Then they conspired with someone pretending to be a judicial officer, along with someone pretending to be law enforcement, because that agent of the state had no authority to take the child without law enforcement involved. I don't want the names of those people because there's lots of people that don't know. What I do know is that someone from the state claiming to be an agent of the state, able to enforce the laws of the state, whether it's CPS, whether it's this, someone said that they have the authority to be able to interfere with your relationship with your child. Someone pretending to be a judge said that they have the authority to interfere with your relationship as they conspired with someone pretending to be an agent of the state. And then someone, somewhere in law enforcement was involved in it. whether you knew it or not, someone within law enforcement was involved. You may not have seen the police. They may not have shown up to take your child. But if you don't know whether or not there was law enforcement involved, then that means it was a prosecuting attorney involved. Because that person pretending to be an agent of the state had to act under law enforcement authority to remove your child. So if you don't know who it was, I would put prosecuting attorney. Because the prosecuting attorney is the only one that can delegate the law enforcement authority, because that's the highest law enforcement officer in the county. So that person portraying themselves as an agent of the state to interfere with your right to have a relationship with your child, which could be the guardian ad litem, could be a number of different people. But nonetheless, I want to get everybody in the same procedural situation. I want to get them down to the most basic level. And what I do know in every single case, doesn't matter who they are, someone pretended to do something that they couldn't do, interfere with your right. Someone pretended to be a judge, colluded, and created a conspiracy by between that someone that said they could do it in order to advance that interest, right? And then someone delegated law enforcement authority to be able to take away your rights without lawful authority, because that would be unlawful, right? So what I'm saying is that once I get everybody into that procedural situation, I can litigate that in my sleep, right? I can argue that, yes, someone did do this. Someone has conspired and someone else delegated law enforcement authority. If I get back to Washington, D.C. in 37 days, and if that Supreme Court of the United States hasn't pulled their head out of their ass, I'm sorry, right, and decided to go ahead and protect themselves from this obvious train wreck that's on their way right now, with 500,000 actual crimes that we can hold them to trial on, every single one of them, then once again, I wonder how many, and that's just the tip of the iceberg. I told everybody that if 500,000 is enough, I'll go get 10 million. Because we've got 70 million people who are charged with a convicted of a crime here in the United States of America. Every single one of them is a victim of this issue. And so if that's not enough, I'll go get more. But nonetheless, if I make it back to Washington, D.C., and they haven't addressed this issue before I get there, then we're going to have to do this in a public forum. We're going to do this, right? And it's not going to go very good for them, because once again, remember, I have 2.9 million people who have rights standing behind me that are protected by the Constitution of the United States of America, that I'm fighting for their rights, and standing in front of me is one criminal. And behind him or them is 40,000 traitors. Who's going to win? The people have rights, government has powers. But the powers are limited in order to preserve the individual liberties of the people. These people have the right to be free. These people have a right to have a relationship with their family. These people have a right to have a relationship with their wife and their husband. These people have been denied rights by 40,000 traitors, being led by one giant criminal. We're going to address the criminality of that institution, and if they don't want to have this debate with me, that's fine. We're going to do it in public, which is why I'm out here doing this. Right? 40 press conferences, 40 of these events, speaking to people in the United States, informing you guys over and over and over again of what's actually happening, because as long as government ignores me, that's not a detriment. That's an advantage. Because I'm controlling the narrative. If they don't want to come out here and they don't want to debate me on this, that's fine. I'm going to continue to speak and inform the people of the United States of their rights, because of the abridgment of the obligations of this government. And as I continue to do this, by the time I reach Washington, D.C., by the time I get back there, we believe that there won't be a single news station in the country that won't be there to meet me, greet me, and watch me as I walk the Supreme Court, finally deliver oral arguments on behalf of the United States. Because I do believe that institution is going to wake up and address this, because they're going to be too afraid of what's going to happen as they see this train continue to come. Yes, ma'am.
So now that the judges have a workplace injury, they've put their head up their own asses. What if they claim that they didn't know better and they want money for their own injury?
What's the injuries?
Their injury is that they were told that they can do this.
So that's not an injury, because right here, all persons are presumed to know the law. Any person who acts under any unconstitutional statute, he does so at his own peril and must suffer the consequences. There's no injury to the judge. Judge had obligations. Judge made a promise that they would do certain things. You see, I too took an oath. But you know, 26 years ago, and I promised that I would support and defend the Constitution of the United States against all enemies, foreign and domestic. And I'm a man of my word, right? I'm going to do the things I said that I would do because the honor is the one thing that they can't take from me, right? So when I learned that I was doing something contrary to what the law demanded, when I learned that I was breaking the law myself, I had no choice here. I had to do this. Even though I don't get paid, no one said that I was ever going to be paid for the honor that I have to maintain. You know, even though I'm doing this by myself and none of these assholes are here helping me. In fact, I'll tell you, DOJ top brass has called me and said, oh, we support you, we appreciate what you're doing privately but not publicly. I'm like, well, thanks, right? I've had governors, meals with governors that said, we support you privately but not publicly, right? I've had meals with congressmen and senators that have said, we support you privately but not publicly, right? What that tells me is that no one's going to help me get there. This has been a really, really difficult journey because no one is here helping me. But no one ever said, I appreciate that, yes. No one ever said that anyone was going to be there. When I took that oath, no one said that anybody was going to be there fighting with me. No one ever said that reinforcements would come. That was a promise that I made to the United States in that Constitution, and I'm a man of my word, and so I have no choice here in this matter. But to answer your question, neither did any one of these other guys. You know, these governors that say, oh, well, we support you, we appreciate what you're doing, we believe in it privately but not publicly. Well, guess what, Governor? What's going to happen when I get back to Washington, D.C., and I'm going to have to tell everybody that, yes, Governor Stitt, you said that you support me privately but not publicly. Well, unfortunately for you, Mr. Stitt, that means that you're aware that you're doing things unconstitutionally, but you don't have the fucking courage or the fortitude or the honor to step up and do it right. That's not honorable. That's actually a criminal. Right? That's a traitor. I had a lady just yesterday message me. She was in a courtroom earlier, or late last week. And she said that the judge said to her, she started bringing up the things I'm saying, right? Oh, jurisdiction, these other things. The judge said to her, Constitution doesn't apply to my courtroom. Well, that's nothing new. We hear that all the time. I've been in no less than 70 courtrooms in the last year and a half across 13 states where the judges made that statement. Constitution doesn't apply to my courtroom. Absolutely insane statement because absent the Constitution, you don't have a courtroom. But nonetheless, they made that statement. Well, she made that, she brought up the Constitution, the judge said, oh, that doesn't apply to my courtroom. And then she said, yeah, but everything's changing. Look at Chevron, and look at, you know, the DOJ memo to Grassley, and look at, you know, yes, everything's changing. You know what the judge said? The judge said to her, yeah, everything's changing, but not in time to say to you. Yes, everything's changing, but not in time to say to you.
Which implies balance.
It implies, right. So that establishes mens rea. For a crime to be committed, you've got to have three things: mens rea, actus reus, and corpus delicti. Corpus delicti is the body crime, what actually occurred. Actus reus is the criminal action that is protected. It would be the obligation that you would have. Mens rea is the guilty mind. You have to have a guilty mind in order for a crime to be committed. Now, a great example would be like these no contest pleas, right? When you go into court and you say to the judge, I plead no contest, right? Well, what's happening there is that you're saying, I'm not guilty, but I'm going to agree to say I'm guilty because I believe that the prosecutor has sufficient evidence to prosecute me. An Alford plea, right? The judge can't lawfully accept an Alford plea because you didn't say you were guilty. And absent mens rea, you cannot have a crime committed. Without saying, yes, I'm guilty of this crime, without the mens rea, you cannot have a crime committed. That's why I say that, you know, there's certain expertise that's missing from that courtroom, because if you're agreeing to accept a plea from someone that's saying to you, I'm not guilty, but I'm going to say that I'm guilty because I believe the state has enough evidence, you cannot accept that plea, Judge. Because they just said that they don't have a guilty mind. But my point is that you have three. You have three requirements. A criminal demeanor. This is Sir Edward Coke, for God's sake. Right? Of course, you judges and prosecutors, you have no idea what I'm talking about because you haven't been trained in this particular stuff. But Sir Edward Coke, criminal demeanor, three elements of crime. That's why an attorney, if they were properly trained in how to practice law, properly trained in how to defend someone, they would know that all you have to do is attack any one of the three elements of the criminal teetering and eliminate one of them, and you no longer have a crime. Right? But you attorneys, you don't practice law. You don't know how to do this, right? But when you have actus reus, corpus electi, and you have mens rea, those are the three elements of crime. Eliminating one of those three elements, and crime's gone. Poof, it doesn't exist. So if you show that this person didn't have criminal intent, right, a guilty mind, crime's gone. If you can show that they didn't break the law, right, actus reus, poof, they're gone. If you can show that there's no body of the crime, there's no crime that was committed, because there's no party, there's no offended party, there's no aggrieved party, then you lose corpus electi, right? And any one of those three, absolutely one of those three elements of the crime, then the criminal act is right to point. So if you want to address a criminal matter, attorneys or anything else, you would attack one of the three elements. So my answer, or my response, and that was a very, very roundabout way to get there, is that, yeah, this judge, he stated in that courtroom, I know that what we're doing is wrong, but we're going to continue to do it until such time as I'm directed otherwise. Which just so happens to be the exact same response that we got from the Attorney General of Rhode Island and the Attorney General of Washington on this particular issue. The Attorney General of Rhode Island, he was just campaigning to get reelected, right? And he said during a campaign speech in front of a group of high schoolers, recorded, right? Like on the news, he said, yes, I'm aware that many of these laws are unconstitutional, but we're going to continue to enforce them until directed to do otherwise. That was his own words. The highest legal officer, the chief legal officer of the state says, yeah, we're doing things unconstitutionally, but that's okay. We're going to continue to do it until we're told we can't do that anymore. Well, unfortunately for you, Mr. Attorney General, along with many other of your colleagues, that's called sedition, and that's called treason. Because when you promise and you take an oath to support and defend the country, when you swear fidelity with and to the laws of the United States, and then you willfully choose to abridge that which you are bound obedience to, that is the very definition of treason, right? And that makes you have a really long neck. Once again, I want you guys to understand that that's not the resulting outcome that I'm asking for. That's not what I'm seeking, Attorney Generals. I would really like you guys to step up, because it would be a whole lot easier for the people of the United States if you would just fucking accept responsibility for the despicable, treasonous, unconstitutional, unlawful acts that you guys are committing once shown that you're committing them. But if you don't want to do that, I'm not going to control the outcome. The outcome's going to be up to the people of the United States. If the people decide to act within their lawful authority to address your treasonous behavior, I'm going to have to support them. And I'm telling you right now, they are 100% lawfully authorized to be able to do it because our laws permit it. One more thing. God says in the opening chapter of the Bible, he says, don't eat the fruit of that tree or you most certainly die. I'm going to tell you right now, you public officials, you might want to open up your Bibles. You might want to get them out. Turn off your TV for just a little bit here and get to know God just a little bit better. Because if you eat the fruit of treason, the punishment is most certainly death. Right? He wrote about it. He warned you. So I would suggest that you just wake up, pull your head out of your ass, and let's work together to fix this problem. Because if you don't, you know what the outcome is going to be. Yes?
Well, I want to say thank you. I'm going to have to leave shortly, but I appreciate all that you're doing. I hope you have great success. I'm absolutely shocked at what's happening in our court. I'm not shocked, I should say, but everything you're doing is well needed. I believe everything is for a purpose. I feel like there's change coming, so thank you. I have one quick question, and you might have touched upon it. The administrative arm of the courts, right? That's like a whole machine in itself. Do they have judicial immunity because they're extensions of the judges? Can we go after them for crimes, for misconduct, for perjury? Yes?
So I talked about this a little bit this morning. So what I used to do in the government was I used to be very high up in government, national security, homeland security, and stuff. And what our government does, we create diversionary tactics. So what we do is we get the public looking in one direction so that they don't see what we're doing in the other direction. And so there's a number of things that I would love to make people aware of. I talked about it this morning on the live, but let me clarify them here. So first off, Chevron, the Chevron ruling. You guys are familiar with that? That was June 28th of last year. So I finished serving all the state attorney generals on June 6th of last year. June 6th. So between June 6th and June 28th, the court even stayed an extra couple of weeks to make that Chevron ruling. Chevron was the result of the work that we're doing, right? The pressure that we put onto the attorney generals, because we were going around the country and we were saying, prosecuting attorneys all across this country are bringing the incorrect charging instrument. Judges, you are complicit in this crime because of your negligence, because you're not making sure the proper charging instrument is in place. But because of Chevron, because they wrote policy and then directed all their agents to go out and enforce that policy as though it's law, and then they started not bringing these criminal indictments and started doing information instead because that was their policy. They deferred to them for ambiguity. Then what that was the judicial branch saying to the executive branch, no, you don't get to create law. You don't get to do that. And they directed the judicial branch to obey law. Now, that's what Chevron was all about. Now, Chevron was what she's talking about here, is the AOJ, is the administrative law. So going back even further, September 29th of 2023, I delivered the writ to the United States Supreme Court in Washington, D.C., the writ that we're now working to litigate. The clerk of court refused to docket it. That was their response back. We're not going to docket this. Well, that's okay. That's obstruction of justice. We'll deal with him later, right? I wasn't worried about the fact that they were refusing to docket the case, right? But, because we'll address it eventually. But what happened was September 29th of 2023, I delivered the writ to the Supreme Court. They refused to docket it. Then on November 11th, we got Justice Gorsuch, United States Supreme Court, released a judicial notice to every single federal judge across the country. Readily available. You guys want to read it? Readily available. Lots of people have it. What he said most of the prisoners here in America are there illegally and unconstitutionally because the courts are proceeding under administrative law and not common law. He went on to say that most of the children that are being taken from their families being done illegally and unconstitutionally because the courts are proceeding under administrative law and not common law. And then he added a third element. He said that most of the property that's being taken from the people of the United States being done illegally and unconstitutionally because the courts are proceeding under administrative law and not common law. To understand what Justice Gorsuch is getting at there, we got to look at the three branches of government and what their roles are. So the first branch of government is the legislative branch. They're there to legislate. That's why Clause 1, Article 1 says all legislative power is vested in the Congress of the United States consisting of a Senate and House of Representatives. So all power to make, amend, or destroy laws is vested in the legislative branch. Legislative branch can only create law, and law is the only thing that affects people. People are affected by law. Second branch of government is the enforcement branch, right? The executive branch. Executive branch is there to enforce the law. That's why prosecutors work for attorney generals work for the president, and attorney generals are the highest law enforcement officer of the state. Because they're enforcement. They fall under the executive branch. They're there to enforce law. That's what Chevron was all about. They said, executive branch, you don't get to create policy and then go out and enforce it as though it's law because you don't create law. All right? You create orders. Orders only affect those that can be ordered. People, members of the executive branch. Don't kid yourself. Orders, executive orders do not affect the people because only law can affect the people. Orders cannot. So the executive branch was going out and determining ambiguity in the law, and then they were writing policy, and then going out and enforcing that policy as though it's law against the people of the United States. That's what Chevron is all about. The third branch of government is known as the judicial branch, Article 3. Article 3 is there to administer the laws. They are the administrative branch of government. Therefore, when the administrative branch of government creates a ruling and erroneously calls it law, case law, that would be administrative law. Okay? So when judges create rulings and call it case law, that is administrative law. Thus, Justice Gorsuch said, most of the people in prison here in America are there illegally and unconstitutionally because the courts are proceeding under judge-made rulings and not the Constitution. Right? Most of the children are being taken from their families, being done illegally and unconstitutionally because the courts are proceeding under judge-made rulings and not the Constitution. That's what he was getting at. So that's the heart of what I'm trying to address here. That is the issue. That judges don't make the law. You guys have heard me now for 3 hours arguing about judges don't make law. And yet we live in a society where judges create law. Judge-made rulings. But that's not law because we didn't delegate that forward. So to answer your question, so all of these, so we see something very, very significant happen because again, I deal with government diversions. I was very good at it, right? Because they trained me to do it. And so I know exactly what they're doing. I can spot their diversions from a mile away. And let me tell you right now, this DOJ memo to Grassley, this ALJ thing is not what you think it is. It is a diversion. The reason why is this. Words and actions must align. You can say that these judges are unconstitutional. You can say that what they're doing is not lawful, but if you continue to work with them, your words and actions don't align. So when we get a memo from the DOJ that's sent out to Senator Grassley, produced so that everybody can see it, says, oh yes, all these judges, they're just hearings officers. They're ALJs working for the executive branch. Well, if they were, then wouldn't the executive officer be able to just direct them to act lawfully? Why do you need a memo? If they're your workers, then why don't you just tell them to stop acting? Words and actions aren't aligning here. Which means that they're lying about something. Right? That's the first thing. Words and actions are lying, you're lying. So what they're doing is Chevron, June 28th of last year. Chevron was all about executive branch. You cannot do whatever you want to do. You don't get to go out and create policy, bring that policy to us with the incorrect charging instrument. You don't get to bring information to my judges and say to my judges, please hold these over. My judges will no longer be culpable in this. So they said, executive officer or executive branch, you cannot do whatever you want to do. But the very next week, June 2nd, they came out with a ruling in the Trump immunity case that said, executive officer, you can do whatever you want. Those two rulings, they don't make sense. 1 week, executive branch, you can't do what you want. Very next week, executive officer, you can do whatever you want. I knew as of that moment there was a quid pro quo. Because those two rulings are in direct opposition with one another. I didn't know what the quid pro quo was until a few weeks ago when the DOJ memo came out to Grassley. And then I realized what it was. The quid pro quo is that if we accept what they're telling us, if we accept that these judges are not judges, that they're hearings officers, that they're ALJ under the executive branch, Trump can grant them immunity now. The executive officer can grant them immunity because the Supreme Court granted the executive officer immunity and he can grant immunity onto all of his agents. And thus they can get out of this instead of get through this. That gives them a way out. And so my caution here is that we want to be careful of the diversion. If we buy into the narrative, if we accept what they're telling us, that these are just hearings officers that work for the executive branch, they have a pathway to get out of this. There's a clear path for them to get out. But I'm going to caution you from doing that. So what I like to use is I like to use the analogy of a water gun. A water gun. Because if I walk up to you out on the street and I got a water gun, I point that water gun at you and I say, give me your money or I'm going to shoot you. I'm portraying that as a real gun. And you believe that it's a real gun, that's a real gun. I'm going to prison for robbery, right? Because I'm using duress to take your property from you, right? Through the abuse of my powers of owning a gun. So if you believe that that's a real gun, and I portray that as a real gun, it's a real gun. When you walked into that courtroom, did you ever believe that that person sitting on that bench was not a judge? Did you ever believe that he didn't have the authority to do the things that he did to you? Do you believe that he was just a hearings officer working for the executive branch, or did he portray himself as a judge? Right? Did you believe that he was a judge? And if so, don't call him a hearings officer. You call him a judge, because a judge does not get immunity, because the Supreme Court couldn't grant themselves immunity. But if we accept what they're trying to do, the looky-loo, the diversion, and we say, okay, yep, they're just workers of the executive branch, I'm afraid that they got a path out of it. So I'm saying that was not a hearings officer when you walked in that courtroom. The decisions that that person made was the decisions that only a judge could make, and they portrayed themselves as a judge to you. It was not corrected as a judge by the judicial branch, and as a result, you believe that that water gun is real. You believe that was a real gun because they portrayed it as a real gun, and as a result, that's a criminal who created a contract through the use of duress by someone that had no authority to do it.
Which means the original authority has been manufacturing fraudulent warrants.
So the warrants is a great issue. So the Constitution says that no warrants shall be issued but upon probable cause supported by oath or affirmation. So you got to have probable cause supported by an oath or affirmation in order to issue a warrant. So with this indictment issue, right? The difference between these affidavits that I have and an affidavit that a law enforcement officer produces is when a law enforcement officer gets a call, right? When they get a call, thank you so much. When law enforcement shows up and they say, well, I've got a call where this crime was committed. Thank you so much.
Thank you.
Yeah, thank you.
God bless you.
God bless you. Thank you. So when someone calls up the police and says, hey, this happened, that officer then takes that information, reduces it to writing in the form of an affidavit, and then he submits it to a judge. And at the end of that affidavit, it says that I submit the following information as truthful, factual, and correct under the officer's oath. That officer was never even a witness to the incident. How can the officer submit this as factual when he wasn't a witness to the event? And yet, no warrant shall be issued but upon probable cause supported by oath or affirmation. The difference between the state's affidavits and my affidavits is that I, as the evidence custodian, I'm not signing this saying that this information is truthful, factual, and correct. I'm going around the country to you, and I'm saying you attest that this is correct. You are saying under penalty of perjury that this information is correct because you are the witness, not me. All I am is the evidence custodian. All I am is law enforcement. I collect the information from you, who's the victim, and under penalty of perjury, you attest that this is correct, which means that this affidavit is valid for the issue of warrants under the Fourth Amendment. Their warrants are not, because they come from someone that was not a witness to a crime. Because law enforcement can't take the oath saying, no, the oath must come from the individual who is swearing that the following information is truthful, factual, and correct. Yes, we have a major Fourth Amendment violation issue that exists right now, because these states are issuing warrants without probable cause supported by oath or affirmation, because the actual person that was a witness to it is not attesting to the accuracy and truthfulness of the information. That must come from the witness, from the victim. All that I am is an evidence custodian. All I am is law enforcement to receive the information from the actual victim, who is the one that is saying that this is truthful, factual, and correct. Okay? Thank you. So let me run through this here between the two. So we have two different affidavits, guys, and this is the first affidavit is already available on the webpage, on our website, www.tanawah.com. That's TANAWAH.com. You can go out and you can download the affidavit. This is for the information issue, or the indictment issue. All right, it's already available. We're only sending these affidavits now to one address. I used to have 10 post office boxes across the country. We only have one now, because I'm going around the country now and picking up all these boxes that we've been having these affidavits sent to for the last 8 months. So we don't want a whole bunch sent to Long Beach, because I'm about to pick up Long Beach's post office. We don't want a whole bunch sent to LA, because I'm about to go pick up LA's. Right? I've already been to Minneapolis. I've already been to New Hampshire. I don't want more. So the only post office box that we're still using now is going to be Chief Carey, United States Navy, out of North Carolina. All right? There's a video that's on my TikTok page, on my Facebook page, on my YouTube page that says that address. Right? Readily available. That's the only one that we're doing. P.O. Box 61 in Bridgeport, North Carolina. You guys, if you need that address, go there. All of this is going on to the website. So Jessica is now, she does web development. I don't do that, but she's doing some additions to the web page, right? She's adding a page. So you guys can see real time how many boxes of paper we have filled. Because we need 200 boxes of paper to reach the 500,000 criminal affidavit number. 200 boxes of paper. So as we check off these boxes, you're going to see firsthand every box that is being filled. And once we reach the 200 number, you all will know that we're at 500,000. Right? And that's the number that we're going for. That's the number that God says is enough. And that's the number that we seek to obtain over the course of the next 37 days before I return to Washington, D.C. Right? I don't know the numbers. I believe we're at around 380,000 so far. But it doesn't matter. We're going to make it. You guys know. So you can download the affidavits, the indictment affidavits. You can download them from the website, and they get them sent off. If I'm coming to your city, remember. So tomorrow we're in Oakland, California, right? Then we're heading east, guys. There's a little bit of a change in schedule that's probably going to happen. Not certain on that, but probably. But we will either be in Chicago, Denver, or another city, and I'm not going to say what that city is because you guys know that I like to keep government on their toes on where I'm at. But we're heading back east, and we're looking at having a little bit of an adjustment in schedule, and you guys will be notified of that. So we might be in Texas, we might be in Illinois, we might be in Colorado, or we might be in Utah. I don't know, on Saturday. But we'll be in one of those places. Provided we get the funding that we need to be able to make this happen. So remember, I don't work for money. So we need donations, guys, in order to make this continue to roll. But nonetheless, Saturday will be the next stop. After that Saturday, we will be back on schedule pretty much, which the schedule is Chicago to Denver to Salt Lake, Sacramento. Then we're down in LA on May 3rd, doing one in Long Beach and one in Los Angeles, both on the same day, one morning, one afternoon. Then we're going back up to Sacramento. We do Sacramento and then we go into Carson City, Nevada. We still got to serve the state of Nevada, guys. That's going to bring in 45 states. 45 states that have been served. 45, right? And that only leaves us with Vermont, Maryland, West Virginia, Alaska, and Vermont, Maryland. South Carolina, Hawaii, and Alaska. 5. That's all. So we'll be at 45 after that. So we're going into Carson City after that. We'll hold another rally in Carson City, and then we're heading down south. Guys, we're bypassing Phoenix as of this moment. That doesn't mean that we won't add to it, but right now we are not looking at a Phoenix stop. I know, guys, Arizona is a big hot button. But guys, we're very, very limited in time. If I can swing it, we will make a stop in Phoenix. But a lot of this is going to depend on funding and availability. We've got to be back in New York for the final stop on June 6th, once again, okay? So June 6th is the final stop in New York. But we're going up the bottom, guys. We're doing 5 stops in Texas. And I know that you guys, I know that some of your states are missing out, but you got to understand that the highest incarceration rates are in Texas and Florida. That's why we're hammering Texas the way that we are. That's why we're hammering Florida the way we are, because we need to look at those particular locations because, again, 2.9 million people whose rights and freedoms have been robbed from them by this government standing behind me. I need those people to rally behind me and push me into that court. They are the ones that's going to be help with these affidavits. The family unit, you guys can be helping get them, but we've got to get that done. We've got to get that happening. Okay? So that's why we're concentrating so much on these particular states. So Texas, then we're into Louisiana, into Mississippi, into Alabama, and then on to Florida. We've got a whole bunch of stops in Florida as well. I hope that Society First, Joan, if you're on this live, Joan, we're going to be reaching out to you here real soon. I'm going to need your help, guys. Right? Please help me out. Society First is an organization that I used to work with down in Florida. They're doing amazing work on the life without parole stuff. and they are going to be very, very important to the success that we need in the state of Florida. Joe and I'll be reaching out to you real soon to solicit your support. And then we're heading up the East Coast. Yes?
Life without parole is just code for slave anyway.
Life without parole is not about, you cannot give a person life without parole because you don't give them any sort of hope for a future. But more importantly, the issue that Society First is dealing with is that the state of Florida, it's written in their constitution, their inferior state constitution, that you cannot give someone life without parole. Can't do it. And yet there's 40,000 people currently serving life without parole in the state of Florida, even though the state constitution says you can't give life without parole. Over 40,000. In fact, there's so many people serving life without parole in the state of Florida that they have more people serving life without than 16 states combined plus 1,000. That's how many people there get. And yet they live in a state that says, oh, we can't give life without parole. And yet they give it out every single day. Now the problem that Society First has been having is that when they bring this issue up, right, and they take it to a state court, the state says, I'm not going to hear it. State Supreme Court won't hear the case. They won't hear it because they just want to ignore it, right? So they're not getting any action in the state court because the state has already foreclosed upon, yeah, we can do that. Even though the Constitution and people say we can't, we're going to do it anyway. So they can't get action in the state courts. So then they go into the federal court. And they say, federal court, please preserve our rights that the states are saying. And the federal court says, oh, no, that's not a federal issue. That's a state constitution. Go back to the state and argue with the state. So none of these life without parole is getting any action on the issue because the courts are just jockeying back. The state courts are refusing to even acknowledge it, right? Ignoring it. The federal court says, oh, this isn't our problem. That's the state's problem. Go back to the state. We're not going to enforce it.
It's all just a hustle.
All it is pawning it off and refusing to address the unlawful acts of the agents by the state, right? So Society First is doing some amazing things on life without parole there in the state of Florida, and we're going to get it addressed. But nonetheless, there's ways that we can attack it, right? But you got to get the federal court to actually take action in it, and the federal court's refusing to do it because the state has created a limitation. Because remember, states can't abridge the limits that they have. In other words, they can't eliminate the grand jury such as they did in North Dakota, such as they did in Washington, Oklahoma, and Connecticut. What's that?
California.
Yeah. So they can't abridge those, but at the same time, they can exceed them. Right? So exceeding them, a good example would be, state of Florida said, you can't give life without parole. That's not protected by the federal constitution, but it's extended to the state. So the state created something that's exceeding the protections of the constitution. They can't eliminate, but they can exceed through the state constitution.
So,
and yet the state is refusing to acknowledge their limits by these judges. Yeah. So then we're going to be heading up north, guys. I really hope that Georgia's going to be a good turnout. We need good turnout by the time we get to Atlanta. We've got some groups and individuals that's going to be helping us there. Please come out, and then we're heading up north. Guys, if I'm coming to your state, please come on out. Please show your support. If you can't show your support, do get us the affidavit. We only got one post office box remaining, P.O. Box 63. Chief Perry, he's the only one that's going to be receiving them at this point. We're going to have the familial unit affidavit online very, very soon. We are producing a video maybe as early as today that's going to instruct you guys on how to fill them out, right? And make sure that's posted on the website. But nonetheless, the website is going to have all this information. You'll be able to go there and download it. We know that there's still some issues and still some bugs. We talked with the web developer yesterday, Joe. Joe, you've done an amazing job. Joe the Geek, guys. He built the website for free. There's some bugs. We talked to him yesterday. We're trying to get those bugs resolved so that as we continue to move forward after today's press conference or this meeting, after today, that we won't have those bugs continue to exist. So please continue to like, follow, share. Please comment. Please continue to support the website. We'll have a number of interactive things on the website, where the next stop is, how you can get involved, everything else. We need you guys on the ground because I don't have contacts in Oakland. You guys do, right?
I do.
Well, we need to go ahead and see, the whole point is that I need you guys involved because the only way we're going to get the support that we need to fill these seats, right? The only way we're going to be able to do it is by the locals who have the contacts, who know the people, getting involved, supporting this, and getting behind this. I can't do this on my own. I need you guys' support. So please, if you'd like to share, please donate if you can. We have Cash App, Tribe, Venmo, PayPal. They're all exact same. It's the only way that I get any money to do this because I don't work. I work for free. But we have Cash App, Tribe, Venmo, PayPal. They're all exactly the same. We shall be free. That's WESHALLBEFREE. We shall be free. If there's any other Cash App that's contacting you, any other, they're scams done by garbage, right? They're saying that they're stealing money from you. Those are the only Cash App, Chime, Venmo, PayPal accounts that we have on the tour. We shall be free. We shall be free. WESHALLBEFREE. We shall be free. And guys, I can't do this work without you supporting this, okay? We're on the home stretch now, 37 days left before we get back to Washington, D.C. Thank you guys so much for your time today. Thank you guys so much for your support today. Please get out, please spread the word, and I look forward to seeing you guys out in the field. This is going to be an amazing 37 days. We're in Oakland tomorrow. Please spread the word, please support us, and thank you guys so much. God bless. Have a great rest of your day. Thank you, YouTube. God bless, guys.